Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 24th, 2026. We have 10 bills on the docket, and we're going to start off with Senate Bill 661. Senator Love.
Thank you, Mr. Chair. May I bring up my two witnesses who are on standby? Thank you. Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, members of JPR. Sarah Love, Senator from District 16, here to present to you SB 661. This bill probably looks very familiar to you, and that is because we passed it out last year unanimously. It was the chair's bill. The Senate passed it out unanimously. Unfortunately, we passed it out late, so it didn't have time to make it through the House. SB 661 is the same bill with one change, and that is we added hate crime as a case in which recorded evidence could be offered. So just very briefly, this body is well aware that we're a two-party state, two-party consent state. This bill does not change that, nor does it create an automatic exclusion for audio recordings in these instances. Instead, it allows a court to determine the admissibility of the recorded evidence in limited circumstances, and those are laid out in the bill. Additionally, it gives the person who is unknowingly recorded 14 calendar days advance notice of the intended use of the evidence. As we discussed last year, we are in a space now where victims of domestic violence or sexual violence have often recorded their attacks, their abuse, but they can't use that recording. So this bill is intended to allow that evidence to be admitted at the discretion of a court. So, out of respect for the committee's let's try that again, the committee's time.
There's some crimes happening.
You know, I'm just gonna, as my civil procedure professor used to say, let that lay where Jesus flang it. Out of respect for this committee's time, I asked Ms. Feinstein and Ms. Jordan to be here to answer questions since we did pass it unanimously last year. So with that, I respectfully request a favorable report on SB 661.
Thank you for the bill, Senator. I believe last year I was in full support of this bill. I'm concerned that you're saying it's the same as last year, but you made one more addition to it, because this is about piercing the veil of two-party consent, if I'm not mistaken. Is that right?
Sort of, yeah. It's about letting it in evidence in certain circumstances. Yes.
Without being able to record an incident like domestic violence, domestic assault. Is that the same?
What do you mean without being able to?
Is this the same bill that we passed where, like, in instances of domestic violence, domestic abuse, person was allowed to record without letting the other person know, so it pierces the two-party consent law? So my concern is now that you've added this, like, I've always agreed that in those moments where it's imminent physical bodily injury and harm, all day long, I think it's great that we should be doing this. But now you've added in, though, you made it different than last year because you added in a hate crime under Title 10 of our criminal law article. And so the problem I'm going to have with that is that unless it's something that there's a serious physical imminent bodily injury or harm, I think that hurts this bill. I think it undermines it. I think it undermines the effectiveness of it and the efficiency. And because this body, and I'm not going out here and railing on anything, but I remember some couple years ago, this body tried to pass a law that if somebody wore a MAGA hat, that was a hate crime. They wanted it to be listed as a hate crime having a MAGA hat. That's just not okay. And so I just worry about that. Like, I can't support it with that on there because the intent was to keep victims safe and be able to document and record an incident. And that made me comfortable with this. But when we start here again, we're trying to add something else into it. And we haven't even seen this functioning part. I think it was a great bill last year. So I just have those concerns. I mean, do you have anything?
Senator, I am absolutely happy to talk with you about that. And if it's the will of the body to take hate crime out, that is where we will go.
Last year, because it's such a sensitive issue, I was super, super supportive of it. for the survivors and the importance of that, but the imminent physical bodily injury or of death or bodily injury is significant in the justification of this. So
I hear you. Thank you.
Thank you, Mr. Chair. I also was supportive last year, and I'm supportive this year, but I've read the concerns expressed by the Maryland Judiciary and the ACLU, so I do have two questions relating to their concerns. So the Judiciary makes the, I think, intelligent point that if this bill passes, we are now going to be admitting evidence admitting intercepted communications into evidence in court, which were intercepted by a person who is a felon under Maryland law. So it is a felony currently to intercept these communications. And yet the felon has now acted, and we're going to accept the felon's intercepted communications into court. The judiciary points out the logical concern about that. Do you have any reaction to that?
I do. I have two reactions. One, you have a bill that we're going to hear very soon.
We're going to hear next. Yes, next.
And two, I would like to turn it over, if I may, Mr. Chair, to Ms. Feinstein.
Sure. Huh? Aren't you a co-sponsor of this bill? I might be.
Good afternoon, Chair Smith, members of the committee.
I am.
I think Senator Folden was just pointing out that Senator West is a co-sponsor on this bill, so thank you for your co-sponsorship. To answer your question, yes, it's still under the current structure of the law would subject the person that made that recording to criminal liability, and it would be against their penal interest. As prosecutors, we would be required to have them advised that it's against their penal interest, and we would have to immunize them if we intend to use that evidence. And that's something that we fully contemplate and know will happen, and we're prepared to do that.
It all makes sense.
Okay, thank you.
Second question is the ACLU, and their concern relates to a single paragraph of the bill that says the court, in order to admit this as evidence, the court must first determine that the contents of the communication and evidence derived from the communication are more probative on the point for which they are offered than any other evidence that the proponent can procure through reasonable efforts. I just wonder how that would play out in court, because attorneys try their cases and some evidence comes in before other evidence. It all can't come in at the exact same moment. So it may well be that this evidence is more logically introduced earlier in the trial than other evidence. And this would require the judge to make a decision before the judge has heard the other evidence about whether this evidence is more probative on the point than other evidence which would come in later on in the trial. That doesn't seem to make much sense. Can you make some sense out of that?
So again, two things. First, I would say I would imagine that because the person who was recorded without their knowledge is given 14 days advance notice, that there's going to be a motion in limine. I mean, hands down, the judge is going to address this up front. With that, number two, I'd like to turn it over to one of the practicing attorneys to also add to that.
Thank you, Senator Love. I agree with you completely. There'd be a motion in limine. But the other thing is I'm a little surprised the ACLU raised this concern, because this language is exactly from the current rules of evidence. And so this is pretty routinely used whenever we have something that falls outside of that long list of hearsay exceptions. There's a catch-all exception that allows the court to consider hearsay, and this language is exactly the same as that in the rules, so everyone is used to doing this. I can say from experience that I've also done this with a proffer. It's, it's really can be very straightforward of, there was no one else around. It's just these two people.
Thank you very much for your answer.
All right. So are you all, I mean, I know you're here for questions, but are you here to testify as well, or just that was good? Okay. Since there are no further questions, thank you all very much. Thank you, Senator.
Thank you.
With that, that will conclude the hearing for Senate Bill 661. We'll now move on to Senate Bill 680 with Senator West.
Thank you, Mr. Chairman. It's a pleasure to present Senate Bill 680. This bill's passed the House 4 years in a row, but has always failed to get a vote in the Senate. So I'm hoping this year we can get a vote in the Senate on Senate Bill 680. It's also that rare criminal bill which has the support of both the State's Attorneys Association and the Office of Public Defender. Furthermore, the bill has no fiscal note. So what this bill does is change a single word in a single criminal statute. It changes the word felony to misdemeanor. The penalty for the crime is left unchanged. All the changes is the characterization of the crime from a felony to a misdemeanor. The crime set up in the statute is the crime of intercepting a communication, whether oral wire or electronic, without the consent of the other parties to the communication. Unlike in 38 other states, Maryland has a two-party consent rule, as I think the members of this committee are well aware. All parties to a communication must consent to it being intercepted. So this bill would merely change the characterization of that crime from a felony to a misdemeanor. Let me give you two hypothetical instances which this bill would impact. First, two gang members are standing on a corner discussing a crime they're about to commit. Someone standing nearby waiting for a bus takes out his cell phone and surreptitiously makes a video recording of their conversation, which of course would include an audio recording of the words they use, and turns the recording over to the police. Under current law, the bystander has committed a felony. The two gang members may have been planning a misdemeanor, but the bystander would have committed a felony by turning that information over to the police. Second, a battered wife sits her cell phone in a location that can capture video and audio images of her husband and captures footage of him screaming at her and beating her and turns the footage over to the authorities. Once again, under current law, the battered wife is guilty of a felony. So Senate Bill 680 is a simple but necessary step to align Maryland law with the reality that cell phone recordings are commonplace. The felony criminal liability imposed by the statute currently is just out of touch with the expectations and the real life experiences of Marylanders. Reclassifying the violation as a misdemeanor brings the added benefit of permitting these cases to be tried in the district court, a more efficient and appropriate venue for most of these matters. It thus reduces the strain on resources of the circuit courts. Now, supporters of this bill over the years have included the Maryland State's Attorneys Association, the State's Attorneys of Baltimore County, Frederick County, and Prince George's County, the Office of Public Defender, the Maryland State Bar Association, the Women's Law Center, the Maryland Coalition Against Sexual Assault, and the Maryland Network Against Domestic Violence. I hope the Judicial Proceedings Committee will agree that the one-word change to the statute proposed by this bill makes sense. I appreciate the committee's consideration of the bill, and I'll be happy to answer any questions. In the meantime, Debbie Feinstein is here next to me, and Scott Schellenberger is maybe on camera. Is he here? He signed up. No, he's not? Well, so we'll just hear from Ms. Feinstein.
Thank you. Good afternoon again, Chair Smith and members of the committee. And thank you to Senator West for bringing this important bill. This bill was conceived of and created in sort of in line with what we were talking about in the prior hearing, which is a need to really overhaul how we're looking at wiretapping, given the ubiquitous nature of cell phones and recording devices, and also the fact that a perpetrator of crime who may be recorded could then get away with their crime because the recording is not admissible. I brought with me a plethora of examples where that happens. The MSAA views this as one step towards moving our wiretapping laws in a direction to enable the state or the defense in certain cases to be able to utilize this evidence in court. Making it a misdemeanor diminishes the seriousness of the offense, which we think is appropriate given, again, the ubiquitous nature of recording devices. And I just want to give an example from actually this morning. My office was talking about a couple of cases where a petitioner in a peace order or protective order case had gone to court and had offered up as a part of their testimony in the protective order hearing that they had made a recording of the abuse. The judge advised them, we can't use that evidence, it's actually a criminal offense. Well, immediately the respondent, the one that was the perpetrator of the violence, went to court, to the commissioner, and sought charges, a felony charge of wiretapping violation against that victim of domestic violence. And I think that's just an example and really shows the unevenness and the way that our approach is just not working, because then the abuser is now being able to wield this as a sword against the victim. And I would encourage this body to consider this bill and other considerations with respect to reforming Maryland's law around wiretapping and to bringing it into line with many other states, 38 other states in the country. Thank you.
Oh, thank you both. And I'm favorably disposed, but I have a couple of questions I don't know the answers to. I get the cell phone, ubiquitous and used, but what about parties that's not what's happening? This is serious wiretapping, egregious illegal activity, and the result of which are used to gravely harm someone, which is one of the things that has happened with this. To me, again, I'm sure you guys have much more expertise. I would bifurcate it because I do think there's a big distinguishing factor, unless you can show me, well, no matter what that is, they've committed enough other crimes that will get them punished appropriately for the harm they've caused. But I get the one incident, I definitely think it should be a misdemeanor, but I don't know about other incidences of one party, violating the two-party consent or using means that were traditionally used prior to cell phones. So anything you want to tell me about that?
Sure, certainly, Senator James. And I also neglected to say that I was testifying on behalf of the MSAA, so just to make that clear for the record, that the MSAA supports this bill, as was indicated by Senator West. I think the important piece in response to your question is really to look at subsection B of section 10402 of the of the Courts and Judicial Proceedings article.
Is that in the bill?
It is. It's on page 2.
Okay,
it's
thanks.
line 9.
Okay, good.
And
All right, here we go.
you can see there that the penalty hasn't changed. So the type of conduct that you're talking about,
Yeah.
so that would go to sentencing. And when you look at what the sentencing guidelines are, and I wouldn't anticipate those changing either, because it's
Okay.
still a 5-year maximum penalty and a fine of not more than $10,000. So we would still have all the same tools.
Okay.
And we would be able to weigh in a situation that you're describing that may be more egregious and flagrant and violative and argue for the higher end of that offense.
So what's the advantage to, then, because I don't do criminal law, I have to look across the way to my dear friend who does it, but I don't what's the advantages of someone getting a felony or the advantage of somebody getting a misdemeanor if it's not directly related to, other than incarceration time, years in jail and amount of fine? Why do we do it?
I think it's a policy and perception argument, frankly, because a felony is perceived as a much more serious crime, and that may inhibit someone from making this recording or being fearful of revealing that it even exists. And that's part of the problem. We may not even know that this best evidence may even exist. So it's sort of an anti-deterrence in some ways. We don't want victims of violent crime to be deterred from
I understand
making the best evidence
Well, I'll
under
have
those
to look up the old English
But-
law and find
right.
out, that
Right.
comes from all of that and get the history of what it once was, even though it looks like it's lost most of that
Right,
meaning.
and I think what you're also pointing to is this tension between, there are situations where a wiretap violation charge is completely appropriate, and there are situations where it's not. So I don't know if further study could be looked at that to make other future determinations, but this is certainly one step in the right direction to reforming Maryland's law in a positive way, given where we are.
Okay, I'm sorry, I'm all about public perception too. I just don't want to give a public perception to other people who commit this crime in a different way for serious harm, who think they just got a bit of a pass. So some people think that less strenuously under this, it seems to me we're sending the same message to those that intend to violate it for extreme and harmful purposes. But I get why you're doing it, and I support it.
Thank you, Senator James.
Thank you, Mr. Chair. So I guess under the way the law is now, because it's a felony, you get a felony, but would it still be admissible in court currently if somebody tried to do this? No? If they do it under this, making it a misdemeanor, would it still be admissible in court?
No, that's
So it
why we
doesn't
need to
change
pass-
anything?
We need to pass the previous bill plus this one together and then all of a sudden, the evidence can come in court.
And then I guess that's the point I'm making, is that it's not allowing the admissibility of the evidence, which is really the important part of what we're trying to accomplish, unless I'm missing something here.
Well, I think they're both. The previous bill is really important in terms of getting the evidence in.
Well,
This bill is important.
Components of the previous bill.
So that the perpetrator of the bad conduct can't file a complaint against the person who is innocent, but who had a cell phone that recorded what happened, and try to get the state's attorney to put that person in jail for committing a felony.
it's hard to call someone innocent when they're recording. I mean, if they didn't have it by an intent to do it, then it was
But the
recorded.
simple fact is the vast majority of us, when anything happens, pull out our cell phones and record whatever's going on.
I'm not fast
And that's
enough
a
on the
felony.
camera part. So, thank you. What other, is the 38 other states, and I'm sorry, Debbie, I don't know this one, but are they don't have two-party consent? Is that what that is? Or is there just, they have the same penalty on the books?
One-party consent, right. 38 states have one-party consent.
One-party consent?
Right.
Okay, that's all I needed to know. I wanted to
Okay.
make sure that was,
Sure.
thank you.
Sure, thanks, Senator Folden.
Thank you, Mr. Chair.
Thanks. If we pass this bill, are you going to come back next year to try to take it off the books? You promise not to? You promise? Well, I know, I'm asking the MSAA, not. Oh, the silence was deafening right there, all right. All right,
If that's a real question, I can answer.
that is a real question.
The real question is, Senator Love's bill accomplishes what the MSAA is looking for.
Are you all going to come back with, because this bill adds another exception for hate crimes and not the prior bill. So we can see I don't want this whole thing to accrete. I'm very protective of the statute. We've talked about this before. I actually had the same concerns that
Yes.
Senator Folden expressed. And I'm less allergic to making it a misdemeanor as rather a felony, but I do see where this is going and wanted just a public statement from MSAA as to whether they'll be back next year to add more crimes and to maybe even remove it from the criminal statute.
So, great question. I cannot speak on behalf of MSAA without running it through the proper channels to make a commitment on that. What I can say to you is that neither Ms. King nor I, who co-chair the subcommittee on SVU, would be moving forward next year to change beyond Senator Love's bill if that is passed this year.
That's fair. All right, appreciate it.
Yeah,
Thank
that's
you
what I
very-
can commit
Thank
to.
you very much.
Okay, thank you.
All right. All right, with that will conclude the hearing for Senate Bill 680. We'll now move on to Senator McKay with Senate Bill 745.
Mr. Chair, Mr. Vice Chair, members of the JPR Committee, Senator Mike McKay presenting Senate Bill 745. Now, Senate Bill 745 strengthens Maryland's public safety framework by requiring mandatory training for law enforcement officers as they interact with individuals with dementia and autism. This bill will ensure that both entrance level and in-service police training will include specified instruction to improve outcomes during the encounters with these vulnerable populations. There's a couple key provisions to the bill. It amends Public Safety Article 3-207A16 to expand the Police Training Commission standard curriculum requirements. It adds certain training components to include locating individuals who are wandering or eloping or missing, to include searching of body of waters critical for the safety of most elopement cases, sensory awareness approaches as it reduces stress and prevents escalation, reunification procedures for returning individuals, safety to their caregivers, proper documentation for accountability and continuum of care, and finally, coordination for efficient responses and resource sharing. Why does this bill matter? Public safety and community trust. Officers often serve as first responders in cases involving missing or vulnerable individuals. This proper training is going to reduce the risk and builds trust. Unfortunately, there is a growing need for Senate Bill 745. Maryland's aging population and a rising dementia diagnosis increases the likelihood of police encounters. Autism prevalence is also rising. Families need assurance that law enforcement understand these conditions. I tend to believe that this is in alignment with best practices. It reflects a national standard for law enforcement training on disabilities. It also complements existing requirements for cultural sensitivity and disability awareness by adding specific actionable skills for dementia and autism scenarios. And my closing argument for support of Senate Bill 745 would be this. This is a common sense, life-saving measure that equips law enforcement with the tools to protect Marylanders' most vulnerable residents. It promotes compassionate policing, it enhances public safety, and more especially, it strengthens the community confidence. With that, I'd like to turn over to my panel, and then we'll be glad to answer any questions you may have, Mr. Chair and committee members.
Thank you, Senator McKay. Greetings, Chair Smith, Vice Chair Walden Stryker, and members of the committee. My name is Sherry Bailey. I am a mom, but also a caregiver. In 2014, I gave birth to twin girls, Lana and Layla. Layla was Hopkins' first case study of a very rare syndrome. She wasn't supposed to make it past 2. She's now 11, nonverbal, and has since also been diagnosed with autism and epilepsy. In 2020, Layla eloped. She didn't get married. She left the house and almost died. In the country, elopement is a crisis. In Maryland, it is as well. Maryland leads not just in stats in some areas, but we can also lead in the way that we respond to elopement emergencies. 49% of children with autism will elope at least once. When you look at a room full of, let's say, 100 kids with autism, about 50 will elope, which is the fancy word for wander. In 2024, the leading cause of death was drowning. I want to say that again. In 2024, the leading cause of death was drowning, with 91% of children eloping drowning. So here I give you Layla, nonverbal, leaves the house or schoolyard or wherever she is publicly and elopes. She finds some water that she loves. She goes in and may never come out. This bill is so important because it covers lifespan. Whether you're a person like me with a child who has developmental disabilities or autism, or you're a caregiver of a loved one with dementia, which 60% of individuals with dementia elope, this bill matters. First responders can help since they are typically the first to respond. I ask you to look at Senate Bill 745, and I urge you a favorable result. Thank you.
Good afternoon, Chairman and Vice Chair and members of the committee, and a special shout out to my senator, Senator Henson. I am Dorinda Adams, a proud volunteer with AARP Maryland, and I have submitted written testimony. So I'm not going to read that, but I want to make this clear that this has been a partnership. And I have that luxury of working with colleagues, friends, family, and former colleagues as well around this issue. And that is what is so important, because I have always heard the term elopement professionally, but I hadn't really thought about it from the perspective of the 50-plus population when we think about autism. Or we think about autism, we think about younger people, but when we think about aging, we think about it from the cognitive challenges. I have heard from so many people in my life, just in this short time across the lifespan, that have said, oh my gosh, this is part of my life. This impacts me. And I hadn't thought about it a lot, but guess what? My father, who passed in 2022 and had a long history of being diagnosed with dementia, he was a farmer, and he loved to wander. And it was also where he chose to wander, often in locations, and I see my time is up, but it's personal. And so as a proud AARP Maryland volunteer, we asked the committee for a favorable support of Senate Bill 745, and thank you.
Good afternoon, Chairman and members of the Judiciary Committee. I'm Linwood Alston, the Chief of Police for the City of New Carrollton and a former commissioner on the Maryland Police Training and Standards Commission. I'm here today in strong support of Senate Bill 745, the LEAD Act. This bill ensures that Maryland law enforcement officers receive specific training regarding individuals with dementia, autism, and particularly in situations involving wandering, elopement, and missing persons. From a law enforcement perspective, these are not routine calls. They are high-risk, time-sensitive emergencies. Individuals with autism who elope are often drawn to water. Individuals with dementia may become disoriented within blocks from their home, wander into traffic, and appear uncooperative when they're simply confused. Without proper training, those behaviors can be misinterpreted. Misinterpretation can lead to escalation. Sadly, escalation can lead to tragedy. The LEAD Act ensures officers receive practical and operational training that saves lives. I also come before you today, not just as a police chief, but as a son. My mother is currently facing the realities of dementia. I have seen how quickly confusion can set in, how someone who once guided you through life can suddenly become unsure of where they are. If she were to ever wander, I want the responding officers to understand she's not resistant, she's not defiant, she's afraid and confused. Training transforms reaction into compassion. Training transforms uncertainty into skill. Training saves lives. This bill protects vulnerable individuals, supports families, and equips officers with the tools they need to respond safely and effectively. I respectfully urge a favorable report on Senate Bill 745. Thank you for your time.
Good afternoon, Chair Smith, Judiciary Committee. My name is Reginald A. Lawson. I come to you as a former caregiver of my late mother, an author of the book At Home with Dementia for Caregivers, as well as a certified first responder dementia engagement trainer. During the early stages of dementia, elopers go out for just a couple minutes and return on their own. However, as they progress through the lifespan of dementia, their compromised minds rob them of the ability to return. My mother averaged 6 elopements a month. She often would be standing in her front yard or at the corner, 30 feet from her front door, not knowing where she lived. Oftentimes, neighbors would bring her home, startled by her attempt to come through their front or back door, thinking it was her home. Dementia elopement is a psychological as well as a spiritual need. For example, oftentimes she felt and others, they had to attend a funeral that did not exist, or they had to go and see a loved one in the hospital that didn't exist, or they had to be on time for a job because they had the integrity that they no longer had. And the worst that I found is that they felt there was a stranger in their home when they would look in the mirror and not recognize themselves, and so they would look to flee. Our trust in first responders is the highest during our most darkest moment. Our world turns frightening when elopement happens, causing us to fear the ring of the telephone, the knock at the door, or the arrival of a patrol car. Once dementia elopers are encountered, there's only a few seconds that first responders have to establish the critical trust that is needed. If they don't have the proper engagement skills, the outcomes can be severely difficult. I currently train the Maryland State Police in terms of their in-service classes. Thank you.
To the sponsor and to the speakers, particularly the last speaker, that was so eloquent and powerful, and brought it to life for me, what you faced and what so many people face. And I've lost a child myself, so, you know, I know where we are, okay? So I just wanted to commend you on all that. And I just did want to ask this one question. I didn't see support or opposition from law enforcement. So is that a good sign, Mr. Sponsor of the bill, or is that, can they do that with existing resources? I mean, I think it makes great sense. I'm just wondering where they are on the bill, or if they were even notified of the bill, or anything. You can tell me about that.
Well, I believe they were notified about the bill, yes, ma'am. I take this as a good sign. Because I trust that they would have reached out.
Silence is golden, right?
That's exactly correct.
All right, thank you.
Thank you.
Thank you very much, Senator. Further questions from the committee for this panel? All right, thank you, Senator, and thank you all very much. Thank you. All right, I have a few more witnesses signed up. Melody Hassan and Therese Hessler. And then we have one person joining us virtually, which is Dr. Cross. And then, am I missing anyone else? Okay. Okay.
Yeah, so thank you. I had signed myself up in case we were across the street on the cross file, so I appreciate that, Mr.
Oh, great.
Chair.
All right. That's awesome. Yes, please.
Hello, I'm Reverend Melody Hessian. Thank you, Chair and Committee, for the opportunity to testify. I'm an assistant to my Bishop for Public Policy, and I'm here testifying on behalf of the Delaware Maryland Synod of the Evangelical Lutheran Church of America in favor of SB 745. While most people might assume that they will never become impaired and disabled themselves, many people in fact will at some point in their lives. All life emerges within the natural world and is limited and conditioned by it. I'd like to read from one of our church's social teachings back from 1998. In contrast to a Christian view of a human being as free in relationship, the most prevalent mindset within this culture, often present even within the church, champions individual autonomy or individual independence. We believe this view of individual autonomy is false. The actions of all people require interdependence and are limited by natural causation, personal situation, and location within a given social context. All people are free to care for each other in ways that are appropriate, purposeful, and meaningful to everyone involved. We believe that law enforcement training in skills that are helpful for interacting with people who have the disabilities recognized in SB 745 will not only help keep vulnerable people safer, but will contribute a positive shift towards more life-affirming practices in the duties of our local law enforcement to serve and protect all Marylanders. So we urge a favorable report. Thanks so much.
Excellent. Thank you very much. Reverend, questions from the committee? All right. Seeing none, thank you. All right, with that, that'll conclude the hearing for Senate Bill 745. We'll now move on to Senate Bill 746. Senator McKay.
Ready? Okay. Mr. Chair, Mr. Vice Chair, colleagues, Senator Mike McKay presenting Senate Bill 746. Now, Senate Bill 746 is about public accountability and public trust. It ensures that municipal law enforcement agencies can act swiftly to protect the public confidence in policing. It also allows chiefs to suspend officers without pay while disciplinary appeals are pending when serious misconduct has already been found by a trial board. This will help maintain the community trust by ensuring officers have sustained disciplinary findings that are not actively serving during the prolonged appeals. This will actually close the gap in current law. Now, current statute allows emergency suspension during investigations and criminal charges, but does not clearly address suspension during the appeals of a trial board decision. Senate Bill 746 clearly provides authority for municipal police chiefs to manage personnel during the full disciplinary process. It will create consistency across stages of police discipline. I am biased, but I do believe this will give us a balanced approach with due process protections. It protects officers' rights by guaranteeing full back pay if the officer prevails on an appeal. It ensures that no permanent financial penalties occur unless disciplinary findings are upheld. And finally, it balances the accountability with fairness of the law enforcement personnel. Now, I do believe this supports effective department management. It gives municipal chiefs an appropriate administrative tool to manage the workforce integrity and departmental operations, while providing situations where departments must retain officers on payroll despite sustained misconduct findings pending appeal. And it will strengthen the internal discipline systems with operational stability. Now, this will also promote fiscal responsibility because it will allow municipalities to avoid from paying salaries during the lengthy appeal process when serious disciplinary findings have already been made. This includes safeguards requiring reimbursement of officers who are cleared, ensuring fairness while protecting the taxpayer resources. It is clear, limited policy change because it applies specifically to municipal law enforcement agencies. It does not alter criminal proceedings or existing disciplinary standards. It simply clarifies suspension authority during the defined stage of the disciplinary process. You'll hear of a story of a small town police department, and this is the genesis of this bill. Entertain any questions, but look for a favorable report of Senate Bill 746. And if I may, absolutely. Thank you very much for that grace, sir.
Mr. Chairman, members of the committee, thank you for your time. I appreciate it very much. My name is Michael Faith. I'm the town manager for the town of Hancock, Maryland, a very small town. We're located in the narrowest part of Maryland. We have 800 tax-paying households, about 1,400 citizens. We have a municipal police department. We're fortunate to have 5 police officers. We're on the western end of Washington County, so we're kind of isolated from the sheriff's department and the state police. So that's probably the biggest reason we have our own police department. We had an unfortunate incident where we had to involve officer discipline. We had an officer that had a complaint. So the process is it goes to the Police Accountability Board. That's a county board. That's a good process. During the interviews, during the investigation, unfortunately, he was less than truthful in some of his testimony, if you want to call it that. And so at that point, once they essentially caught him in a lie, the state's attorney informed us that they would not sponsor his testimony in court. And with a small police department like in Hancock, we don't have a desk job where we can put an officer to work. We have to have them on the street. So that wasn't going to work for us. So we moved, once the Police Accountability Board rendered their decision, our understanding was we could certainly go more discipline, more strict discipline, but we couldn't go less. They recommended termination, which we followed through with that after consulting with counsel. Certainly every individual has a right to appeal. The trial board process is rather cumbersome on municipalities, in our opinion. This would involve hiring a retired judge, a police officer, or locating a retired judge, a police officer of equal or higher rank, and a civilian, having them travel to Washington County to Hancock, probably involving a court reporter to record the proceedings and then render the verdict. And we don't have the benefit of suspending them with pay during this time. So the change we're asking for is very simple. Allow us to suspend them without pay during this time, the trial board appeal, and of course, if they went on appeal, they get all their benefits and money. Thank you very much. I appreciate it.
Thank you for the bill. What's that?
Yes, sir.
So
Next.
I'm curious as to, I'm just trying to get clarity on the understanding of this, because what is the dependency of an appeal from the decision of a trial board under 3-106? Isn't this already covered under the MPAA? There's a process already in place. So does this bill just create a new it seems like this bill is trying to create a new carve-out for a smaller agency.
Well, there's no doubt about it. Smaller agencies have to deal with
Understood, but consistency and application and uniformity under the law is relevant regardless of the size of the agency. So I guess what I'm asking is, I'm sorry, who was the witness? Are you with the town of Hancock?
Yeah, town of Hancock.
Okay. So he came up and testified about that there was an officer that went through the ACC. They made a recommendation. Did they have the trial board before the recommendation, after the recommendation?
So the Police Accountability Board rendered their decision.
If you would, please.
I got a microphone in front of me. I just start talking. Police Accountability Board rendered a decision, and then the officer had an opportunity to appeal. So we were in the process of appealing and securing a judge, police officer of equal or higher rank, a civilian.
So there was no trial board at this point.
No,
You're going off of what the ACC said.
Yeah, that's where we're headed. He elected to resign before we had.
I get that, and I can appreciate that, but here's the problem: is that this is due process. And the reason that the ACC is there is they can make a recommendation, but the officer still has the right to elect a trial board if they don't like the findings of the ACC.
Sure, and we don't dispute that.
But that would change this, because what you're saying is that officer would be deemed basically wrong at that point without having a trial board convened, and a trial board could take up to a year. So this puts pressure on the employee, undue pressure that they could be without pay if they opt for their right to a trial board.
Yeah, Senator, respectfully, my understanding, we in the town of Hancock, we could have had a trial board probably in 30 to 60 days. I
understand that, but that's not the case in all places.
Sure,
and so it sounded like you were making this about economics of trying to get an administrative law judge and the people out there in a court recorder and all that. My concern is that you're taking away. This is an attempted to take away a right of an officer who's already, the LEOBAR, the law enforcement has suffered a great deal of changes in their accountability in the past 5 years especially. And this is something that I hear this coming out, and I have great concerns when we're talking about, because this isn't even just, for your example, that's a serious example, right?
Sure.
Recommended termination. ACC doesn't always recommend termination, but there's still the right to a trial board. There's other areas that don't rise to that level. It might only be, I don't know, a counseling statement or a written documentation of a letter of reprimand. This bill would allow a chief to suspend without pay someone who doesn't agree with that finding without being able to exercise their due process to a trial board.
Certainly, Senator, that I understand what you're saying. They can't make the we're following the recommendation of the Police Accountability Board, so it wouldn't be the municipal chief acting on his own. It would be after the recommendation of a civilian appointed, of a civilian board.
Of an ACC without having the opportunity to go through it's like having a jury of your peers versus having a bench trial.
Right.
And we're taking that away from them.
Respectfully, I would say that I understand a lengthy appeal would go against the officer because it could put them under severe financial strain. But it also, you're talking about taxpayer money as well, which is what I'm trying to look out for. That the taxpayers would have to continue to pay this individual pending the appeal. And all we're saying is if we're wrong.
But there's no level of this. You didn't put any threshold in this. It could be a termination recommendation. It could be something as simple as, you know, a letter of counseling. And I could see a police chief, I know you're going to think this is silly, but a police chief saying, you know what, if you don't agree with this, I'm going to suspend you without pay.
Yeah.
That's leverage. That's not how the process is supposed to be.
Yeah. Well, my understanding was that, you know, we're in situations of disciplinary action like this, we are following the counsel or the verdict of the Police Accountability Board.
I understood that, but there's still an opportunity after that
to appeal.
To appeal. It's a part of the process, whether we like it or not.
Yeah,
it's a part of the process. And if you can get it done in 2 months or 30 days, convene it in 30 days and then fire them.
Sure.
But if we're talking about a month here versus violating every police officer's right this doesn't even apply to the sheriffs. This applies to just the police chiefs. So the crafting of this is unique in and of itself, and I have very, very serious concerns about the application of someone that's appointed by an elected mayor versus someone that is elected by the citizens to protect and defend their community. Mm-hmm. I have grave concerns about that.
Certainly.
Especially, no offense, but some smaller municipalities, there's a lot of politics all the time.
Well, I think the Police Accountability Board takes that out.
Then I would say let the process finish itself.
Sure. Yeah. And again, we're not against the appeal process. We think
you just want to take away the money from the police officer who barely makes a living wage.
Well, no. Respectfully,
gotcha.
we just don't want to.
I got you.
We don't want to involve a lot of taxpayer money.
I appreciate it.
Yeah.
Thank you.
Thank you.
Thank you, Senator. But I look to having a dialogue with you on a solution for this, for the simple fact that what is going to end up happening is you're going to have small departments close. You're going to have, and I don't believe that's in the best interest of safety for the rural communities. And so if we can work on some kind of a fix, I'd appreciate it. Look forward to that. But it's very, very hard for us to have said employee who has to, it's entitled to those processes, but then the town actually has to cover the expense of another officer that is going to have to cover the work and that stuff. So anyhow, yes, sir.
I mean, I would have just liked to have had the discussion before today, but thank you for that. And the idea that, you know, paying an officer for a 1-month assembly of a trial board to give an adjudication that it's going to bankrupt the agency is kind of, or the town doesn't really fit the narrative. So with that, I would just say there's a reason we have a process in place.
Well, I appreciate that and look forward to finding some kind of a solution because we're just not creating a situation out of thin air. We're actually dealing with facts. So thank you, sir. Thank you. Thank you, Mike.
All right, thank you both very much. With that, that'll conclude the hearing or the testimony for the proponents of the bill. We'll now hear from the opposition panel. We'll hear from Mr. Davey and Mr. Shire.
Good afternoon. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we're respectfully requesting an unfavorable report on Senate Bill 746. As stated, the passage of this bill would allow a chief of a law enforcement agency serving a municipality to suspend a police officer without pay during the pendency of an appeal from a decision of the board. Until the testimony just now, I now understand the issue here. And I'll just use Hancock as an example. I didn't represent anybody. This is the first I'm hearing about the case. But the way the bill is written, it's a misuse of the word appeal. you have a case goes to the Administrative Charging Committee. The officer does not appeal. The officer simply requests a trial board. Once the trial board occurs, then if there's a bad result for the officer, then he has a right to appeal to the circuit court. That's the understanding. That is how it works. There is no automatic stay. The way the bill is written right now, at the conclusion of a trial board, if an officer is found guilty and the administrative law judge and the trial board recommends a written reprimand, no suspension days, the way the bill is currently written, the chief can then suspend that officer. Take that back. If he's found guilty, they recommend a written reprimand, and then he says, you know what, I don't agree. I'm going to file an appeal in the circuit court. The chief, the way this bill is written, could immediately suspend that police officer without pay until the end of the appeal process for something he was not terminated for and something he wasn't even given a suspension day for. There are no automatic stays. The bill is so broad, it doesn't cover. I understand what Senator McKay is trying to do for these small police departments. I understand that issue. But the word appeal, as it's written in this bill, is simply being misused. For those reasons, the Fraternal Order of Police would recommend or request an unfavorable report on Senate Bill 746. Thank you.
Good afternoon. Thank you, Chair. I'm Mike Shire with the Fraternal Order of Police as well. Like Mr. Davey, it's kind of crystallizing here. It was unfortunately clear that the gentleman from Hancock doesn't quite understand how the MPAA works. Senator Folden kept mentioning it's the ACC that makes a determination. The gentleman from Hancock kept saying Police Accountability Board. They're not involved in this process. ACC makes a recommendation. The officer either accepts it or rejects it. By rejecting it, they get a trial board. At a trial board, if there is a problem with that trial board, the officer then has an appeal right to go to the circuit court. That is what this bill is talking about, that appeal right. And what this bill would do would severely chill the officer's ability to exercise their due process rights under the MPAA by saying, as Mr. Davies said, you get a written reprimand, okay, great, we're going to suspend you for years. How long do appeals take through the court system? For years while you appeal a minor disciplinary action against the officer. That is an extraordinary penalty, one that an officer cannot withstand. They'd end up having to take that minor penalty when there was a fundamental process with problem with the process. So I understand the small agencies' dilemmas, but the MPAA has in it that the small agencies can use the larger agency processes. They don't have to come up with their own processes. It was specifically designed for those small agencies to have larger agencies run their trial boards for them. Why are they not taking advantage of that? Additionally, it is the agencies that decide when the trial board happens. This could also be used to suspend an officer if it was for the trial board, that you could suspend an officer while you delay the trial board indefinitely. There is no speedy trial demand for trial boards. So you could delay the trial board and keep the officer suspended for years, and then what? The FOP respectfully requests an unfavorable report. Thank you.
Thank you. Are there any questions for this panel? Senator James.
Thanks, everybody. I learned a lot. But with this panel, yeah, I was also, I mean, nowhere in the law that I'm aware of that you can, suspend an employee who has not been finally adjudicated to be X, right? Because
well, believe it or not, there actually is a section that does allow them to do that for up to 30 days.
Well, but in general,
yes, that's correct.
About, right? Because there's all kinds of constitutional and due process. Okay, so I did think about whether or not that would make law enforcement eligible for unemployment. But here's to the gentleman who last spoke. Before he even mentioned this, I thought about, having local small police forces combine their efforts, combine their money, whatever they do to make this, more affordable. But for what you were mentioning, do the larger police accountability boards then, because I am sensitive to what this little town's going through, can they go faster? Can they, or do they may be bigger and they may have money, but they may be so big that it takes twice the length of time. So yeah, the small town doesn't get it done in is still paying the guy, but, you know, it also now a year and a half versus 60 days. Anybody want to speak to that?
It can go as fast as the department makes it. I just represented an officer in a municipal agency in Carroll County. They use the process of Frederick City. It's incorporated into their policy. So it's just a matter of whoever is running that agency, whether they be the police chief or a lieutenant, pushing the issue, getting the board in place. They can either use an administrative law judge in Hunt Valley, or they can use a retired circuit court or district court. It's really up to the department to consider
Right,
how
so
fast they want to move.
So that still exposes the small police force to it being out of their control and there being a length. I'm not citing, I'm not taking a position on this bill so much as I'm saying I'm trying to help Senator McKay solve a very valid problem without the harm of this bill. And I was just asking you if you follow up.
Honestly, with the facts in this case, even though, the case went to the Administrative Charging Committee, they recommended termination. What the town manager also stated is they got a letter from the state's attorney's office indicating that they weren't going to allow him to testify anymore. They could have bypassed the entire disciplinary process and terminated him on his inability to perform the essential job functions of a police officer and terminated him on a performance issue, and we wouldn't even be here.
Well, that's good, but nonetheless, accidentally, Senator McKay landed on an issue that has some merit with these smaller police forces. Thank you all for your help. Okay.
Thank you, Senator James. Any further questions? Senator McKay.
To both you all, if you would work with the town, I would appreciate that.
Absolutely.
Help us craft an issue that obviously the town, myself, is not trying to take away any due process or whatever, but we're just having to deal with the new boards.
We understand that. We looked at the bill. It was overly broad. And until today, honestly, the FOP did not understand what the issue was. So there are ways that this could have been done differently that would have bypassed the even.
We look to have those dialogues.
Yes, sir.
As we go forward. Thank you very much, gentlemen.
Thank you.
Great. Seeing no further questions. Seeing no further questions, that ends the hearing for SB 746. Next, we will turn to Senator Sidnor. Senator, would you like to do 752 next? Wonderful.
Okay, all right, is Ms. Warren again? Hold on one second. Do you know what? One of my witnesses, I know she's here, but she's not in here. So if I can do the other one, and
certainly,
and hopefully in my office they're listening, then we'll let it come down.
And if not, we can pause. That's fine.
All right. So instead, we're going to do
SB 854.
854. What, did they just walk out? Okay. Okay. Very good. All right. And good afternoon. In 2008, the Maryland NAACP represented a class of individuals who had been pulled over for colloquially driving while black. These persons had committed no traffic offense, but had been pulled over on the sole basis of their race. As a part of settling the case, the NAACP and Maryland State Police released a joint statement saying the need to treat motorists of all races with respect, dignity, and fairness under the law is fundamental to good police work in a just society. Racial profiling is unlawful and undermines public safety by alienating communities. That statement was true when it was written nearly 2 decades ago, and it's true today. Racial profiling violates the U.S. and the Maryland constitutions and undermines public safety. Unfortunately, not every federal law enforcement officer has gotten this message, in part because of a concurrent and therefore non-binding opinion written by the U.S. Supreme Court Justice late last year. In his opinion, in Nome versus Vasquez, Justice Brett Kavanaugh argued that race and ethnicity can furnish reasonable suspicion in combination with factors as nonspecific as lives in Los Angeles or works at a car wash. He did not simply downplay the societal harm of racial profiling. He justified the practice and has invited law enforcement to engage in law enforcement practices long considered to be 4th and 14th Amendment violations. Here in Maryland, we're not going to back down from what was said in 2008. Racial profiling is incompatible with a just society, and Senate Bill 854 makes that abundantly clear to all law enforcement officers. Senate Bill 854 ensures that we keep existing constitutional protections and limit federal abuses by enacting 3 reforms. First, Senate Bill 854 affirms that federal law enforcement officers seeking to enforce Maryland laws are subject to the same standards as state and local law enforcement. As we watch federal agents across the country violate individual civil rights, all officers trying to enforce Maryland laws must be held accountable for their actions, regardless of their employer. Secondly, the bill defines racial profiling as relying to any degree on a person's actual or perceived race, ethnicity, or national origin for the purposes of law enforcement. However, relying on such characteristics in combination with other identifying factors may be permissible if a suspect's race, ethnicity, or national origin is a part of a description in connection with a specific offense. The bill makes it clear that law enforcement officers and agencies may not engage in racial profiling or retaliate against anyone who reports incidents of racial profiling. Finally, Senate Bill 854 creates a private right of action, allowing a person to bring a civil suit if they were harmed by racial profiling or retaliated against for reporting racial profiling. This provision creates a clear-cut mechanism to enforce the law and protect Marylanders. Regardless of what is happening at the federal level, we are here in Maryland and know that targeting people based on perceived or actual race is unconstitutional and erodes our communities. Marylanders deserve accountability and justice from law enforcement. With that, I ask for a favorable report on 854 and turn it over to my panel.
Senator Love, good to see you. Members of the committee, my name is David Roca. I'm a senior staff attorney at the ACLU of Maryland. Until a few months ago, there was a clear legal consensus that racial profiling, meaning the reliance on race or ethnicity as a basis for determining suspicion or any other law enforcement action, was both morally wrong and unlawful under the federal Constitution. That the continued vitality of that understanding has now been called into question, as Senator Sidnor has said, by Justice Kavanaugh's now infamous concurrence in the Vasquez-Perdomo opinion, a shadow docket case where the Supreme Court overturned a lower court order prohibiting DHS from relying on race or ethnicity in whole or in part in making stops. Justice Kavanaugh said that relying on race or ethnicity in that context was perfectly fine in conjunction with the other factors, and most shamefully minimize the intrusion and harm that is present in race-based stops. While the Kavanaugh concurrence is not yet law, it clearly raises the prospect that federal law will change. Maryland can and should make clear that racial profiling will not be tolerated or permitted by state or local law enforcement here, and that's exactly what this bill does. And protecting Marylanders in this context is particularly important now, given how our state Supreme Court has traditionally interpreted our state constitution. Our state constitutional provisions are generally interpreted in pari materia, meaning following the lead of the U.S. Supreme Court. And if that happens here, then Marylanders will be unprotected. The bill does several other important things. It adds, as Senator Sidnor said, whistleblower protections. It ensures that when federal officers borrow state law, they are also bound by state law.
David, if you could wrap up, please.
And I'm about to wrap up with my last sentence. It ensures that state and local law enforcement adhere to state law when participating in federal task forces or when they are deputized. Thank you very much. We urge a favorable report.
I think this is the order, who knows? Good afternoon, members of the committee. My name is Mark Graber. I am the Regents Professor at the University of Maryland School of Law, though I should emphasize I'm speaking in my personal capacity and not at all representing the law school, the University of Maryland, or the University of Maryland system. I'm here basically to explain why SB 854 presents no supremacy clause issues, as may have been the case with some previous legislation. To begin with, there is nothing in the supremacy clause or in the Constitution of the United States that forbids a state from providing more protection to state citizens than the Constitution of the United States. We know this well in Maryland. The Supreme Court has interpreted the Constitution of the United States as not protecting a right to abortion. Maryland does, and nobody thinks that it's a supremacy clause problem. Second, SB 854 deals entirely with state law or the federal government seeking the help of state law officials. Supreme Court in Prince versus United States has said the federal government may not mandate that state officials implement a federal law, that they can only do so with permission of the state, and the court has said, and the state can attach conditions to that permission. What SB 854 essentially says, if you want the help of Maryland state officials to implement immigration laws, you must play by Maryland rules. If you don't want to play by Maryland rules, you can do so, as long as you do not ask for the assistance of Maryland state officials. Thank you very much.
Good afternoon. Thank you for allowing me to testify. My name is Randy Williams. I'm a retired Baltimore County Police Sergeant, retired in 2016. I'm going to start my presentation with a question. Who would fight against accountability? I was talking to my cousin who's a retired, medically retired Marine Sergeant, B7. He has PTSD. He watched a couple of his soldiers blow up in Afghanistan. And we were talking, and I'm ex-military myself from the Army. And I was telling him I was going to testify today before the Senate. And I told him what it was about. And we jokingly laughed. He said, well, Randy, who would fight against accountability? And we laughed because we were in the military, and I'm a retired police sergeant. I work corrections as well. And we laughed, but the question is valid. I taught at the police academy for a stint in Baltimore County. And one of the things I taught the recruits was stay in your lane. Legislators create law. Judicial branch, attorneys and judges interpret the law. Law enforcement only enforces the law. What I found as a sergeant over my 20 years in the police department is that officers got in trouble when they made up their own law, and then they tried to interpret it and put it on paper. This bill will take a lot of that discretion away. And how do you hold an agency or individual accountable without defining the law in this state? It's already been done as precedent. Transportation Article 25-113, which is a bias-based policing bill, or law, I should say, in Maryland already. So this would just basically say, we're going to do this generally with racial profiling outside of traffic. Thank you for your time.
Thank you very much. Are there questions from the committee? Senator Folden.
Thank you, Madam Chair. Whoever wants to come up, I mean, we can start with the professor, I guess. You brought up the supremacy clause, and you also made it that this is clearly, in your opinion, this is about immigration, because you brought up immigration. You're the only one on the panel that brought up immigration as a part of your testimony. So in a part that you're bringing that up, one of the things that was also stated was that the other factors of the Kavanaugh decision, that it wasn't just based on race. What was the other factors that the race, I guess, was allowed to be played into?
Well, among other things in the Kavanaugh decision, we talked about employment, language, and a few other factors. Now, I should emphasize, Kavanaugh also emphasized perfectly legitimate factors. Person appears nervous. The person appears like they're carrying a weapon. The person appears in a way that the police officer thinks is likely to have committed a crime independent of their race, ethnicity. But the mere fact that, like my daughter, you are fluent in Spanish, traditionally has not meant that makes you suspicious as an illegal immigrant.
But that doesn't make you, that's the totality of the circumstances. That would be the incumbent part of taking those other factors that you spoke about, that Justice Kavanaugh spoke about, in conjunction with other things, not just one standalone.
No, but in fact, Justice Kavanaugh, what's interesting is Justice Kavanaugh in affirmative action cases said, by totality of the circumstances, we do not mean race can ever be considered. What is unique about the Kavanaugh opinion is that now race can be included, at least in his opinion, totality of circumstances. But notice, that may be wrong as an interpretation of Kavanaugh. I do not mean that nobody up here, as far as I heard, said that the law of the Supreme Court is you can use race. That's very unclear, and it appears Kavanaugh is walking back some of his comments. The point with this law simply says, here are going to be the Maryland rules that the federal government doesn't have to follow. But if the federal government wants Maryland's help.
I appreciate it, but I want to stick to where I'm going with.
Okay.
So to my point, nowhere did Justice Kavanaugh say, based solely on race, that enforcement could happen.
That's correct.
Thank you. As far as the supremacy clause, you came up and said that you felt there was no issue with the supremacy clause. But when I look at it, and we're looking at it in regards to the United States Constitution, to the extent that there's any conflict, federal authority versus state-imposed limitations, the supremacy clause does apply, because federal law is the law of the land, regardless of your state boundaries.
That's correct. However, no, it's correct what you said. However, and this is the important however, this bill does not apply to federal officers applying federal law without state assistance.
Correct. But what this does do is it would prohibit and could potentially put our officers who walk the street every day to protect our communities, it would render them useless to some degree in an effort. If a federal agent got into an issue during their enforcement, this law, as it's written, could put the officer of the local police department responding to help in their matter of urgent time of need in the crosshairs of liability.
Not quite, actually, because in fact, even common law doctrine, when an officer is in trouble, an officer, federal, state, whatever, can call on anyone. In this case, the federal officer is not calling on the state police officer.
But that's not what I'm asking. What I'm saying is that if the officer, during the enforcement of the law, the federal law, and Maryland passes a law that says, hey, you know what, we don't agree with that law, we don't agree with how that's going to be done, so we're not going to have our officers be a part of that, and then that agent finds themselves in trouble. By the way this is written, if that officer goes to support that agent in his arresting of the immigrant, that officer could be held liable. We just had a hearing where they would try to fire him or suspend him without pay until the final adjudication.
Well, it's puzzling, your hypothetical, because
how so?
The following, Remember, what this forbids,
I'm sorry?
what this law forbids is racial profiling. Now,
And
if,
well, hold on, it does,
Senator,
and
if
we
you
don't
could let him-
we don't
Senator.
allow any racial profiling in this state.
Senator Folden,
We don't
if you
allow
could please
any.
let him finish.
here is,
I'm not going to be lectured about what this is when I'm about my interpretation. I'm asking him a question. I am looking for an answer. If he goes sideways, that's not my problem. So if I'm going to get gavelled, I want to know that why I'm being gavelled is justified.
I apologize. My daughter tells me at dinner, Daddy never talks, he just lectures. It's a professorial habit. And
Yes, I see that.
Professor, and it's a problem, so be aware of it here
Okay,
today, sir.
I will.
But you didn't get gavelled, I did.
Okay, I will do my best.
Thank you.
What I'm trying to say is I'm trying to think through your hypothetical. This is what.
Please go through the hypothetical where you see a conflict that this law as written would not create an issue for the responding officer to help a federal partner in what would be deemed an illegal act by this state.
See, as I understood your hypothetical, and correct me if I'm wrong, you said the federal officer is in trouble.
Enforcing an immigration law.
Is in trouble. Now, what that means to me, for example, is the state officer sees the federal officer and someone is resisting arrest. Someone has perhaps drawn a gun on the officer. Someone is in fact hitting the officer. Now, this bill does not in the least way prevent the state officer from helping the federal officer. Why? Because he's not helping the federal officer because the person there is black, the person there is brown. It's because the person has drawn a gun. The person is resisting.
Understood. But is the federal agent enforcing a federal immigration law that would be contrary to what the officer would be allowed to do by this bill?
In this case, he is not asking for the cooperation of the federal officer in enforcing general immigration law. He is simply asking for the cooperation of anyone.
If he's not asking for anything, what I'm saying is if he observes it, he doesn't even have to ask. If the officer sees it, knows that there's an enforcement happening, this bill could put the officer, yes or no, in the crosshairs for liability. You don't think so at all?
My judgment, no.
Okay. And my last question for you is racial profiling already illegal in Maryland?
As I understand it, yes.
Is it already illegal at the federal level?
Now here, that's an interesting question.
Actually, it's actually very much documented in every policy from the DOJ, the FBI, all those agencies have very strict no racial profiling policies, sir.
Well, but in fact, we now have an agency that appears to be engaged in racial profiling. We have a concurring opinion that says this may be okay. So this is simply prophylactic.
So we don't have it. I want to be clear. Let's go back to what you brought up. The decision of Kavanaugh didn't say that it's okay to racially profile. It says with other factors that this could play into context, but it doesn't say on its own merits racial profiling is okay, does it?
No, well, I'm a little confused because what racial profiling means to me.
I didn't ask you that. I asked you the decision of Kavanaugh. What did he say? Did Justice Kavanaugh's decision on its own merits allow by itself?
No.
Or was it in conjunction with other factors?
In conjunction with other
That's
factors.
all I needed to know. Thank you. Thank you, Professor.
Okay.
Thank you.
Senator West?
Thank you, Madam Chair. Professor, could you return to the podium? Sorry to put you on the hot seat.
No.
I want to talk to you about the question of supremacy. I think you're the one who specifically said this does not violate the supremacy clause of the U.S. Constitution. So as I read the bill, it defines law enforcement officer as including any officer within the meaning of Section 2-608 of the court's article, and that in turn adverts to Section 2-104 of the criminal procedure article, which refers to a federal law enforcement officer, means an officer who may make an arrest with or without a warrant for violations of the U.S. Code. So do you agree that federal law enforcement officers are covered within the definition of this, in this bill, of law enforcement officer?
correct when they enforce state law and when they act with the cooperation of Maryland or the Maryland
Why do you
officials.
modify that by when they enforce state law? I don't see that in the bill. Where is there a limitation in the bill that says that the federal officer must be enforcing state law for them to be covered by this bill?
I will leave, this was my understanding. I have not memorized it. I will leave that to the senator here.
You said that earlier, and I went through the bill trying to find some limitation, which says that federal law enforcement officers are only covered when they're enforcing state law. I could not find that in the bill. Mr. Rocco, could you find that in the bill?
Yes, I think what you're
Yeah, here, please.
So, Senator, if you look at the what the bill does with respect to Criminal Procedure Article 2-104.
Where are we now? I'm sorry.
Sorry, if you look on page, page 2 of the bill.
Oh, I was looking, there are two parts to the bill. There's pages 1 through 3, which are written to section 2-104 of the criminal procedure article. And then 3 on is written to section 3-535 of public safety. I have no problem with the first part of the bill. I'm only worried about the second part, which impacts the public safety article.
Right. The two, I think, have to go together because
Does the bill tie them together?
Pardon?
Does the bill tie them together?
Well, they're both in the same bill. The reason they're both in the same...
different, the bill amends one section of the code and a separate section of the code.
Sorry, let me just try to finish my answer.
Go ahead.
I think the reason that the bill ties them together is because...
Where does it tie them together?
Just let me try to get my sentence out, if you will.
I'm sorry.
I'm trying to answer your question.
Okay, I'm sorry.
The prohibition on racial profiling that you're referring to, where
That's in the second half of the bill.
Right. So you are correct, Senator, that the definition of law enforcement officer includes federal law enforcement officer. And the reason that's necessary is because otherwise, if you used a different definition of law enforcement officer, then the prohibition in state law on racial profiling would not apply to a federal officer, even when they were borrowing state law, which is what the first part of the bill, the amendment to Section 2-104 of the Criminal Procedure Article does. Do you see what I'm saying?
Not really. You're talking about two different sections of the Maryland Code.
Yes, I understand.
And the bill independently changes one section of the code in the Criminal Procedure Article in the first part of the bill, and in the second part of the bill, it amends a completely different section of the code in public safety. I don't find any language that ties the two together in the bill.
Well, I don't know that language in the bill needs to tie the two things together, but in order to do what the bill, as I understand it, is intended to do, which is to ensure that when federal law enforcement officials are borrowing state law, that they remain bound by the limits in state law. If the definition of law enforcement officer excluded them, then those limits in state law, and in particular the racial profiling ban that this bill enacts, would not apply to them.
Okay.
So I
understand what you think the bill was intended to do. I don't think the bill does that in the language that's in the bill. Well, that's my problem. But can we move on for that for a moment?
Sure.
So I'm just going to assume that the bill reads the way it reads, and that in the second half of the bill, the part that amends the public safety article, the term law enforcement officer is as defined in that section of the bill.
Yes.
Which adverts to section 2-608 of the courts article, which in turn goes back.
Yes, all of that, you're correct.
Okay. So in the second half of the bill, law enforcement officer includes federal law enforcement officers who are in Maryland in order to make arrests with or without warrants for violations of the U.S. Code, right?
Yes.
Okay. Now, that being the case, I hate trying to deal with this in the context of racial profiling because no one supports racial profiling. Let me suggest, what I want to talk about is the supremacy clause aspects of the bill. So in order not to discuss it in the context of racial profiling, which creates a certain bias in our approach to it, let's instead suggest that the bill would have read, a law enforcement officer or law enforcement agency may not stop, interrogate, or arrest anyone in Maryland on the basis of that person's immigration status. Certainly, Maryland has the right to pass such a law that applies to Maryland law enforcement officers. It precludes Maryland law enforcement officers from stopping or interrogating or arresting anyone based on that person's immigration status. My question is, do we have a right to pass a law which not only would apply that to Maryland law enforcement officers, but also to ICE agents, federal law enforcement officers operating in Maryland? And I don't understand how under the supremacy clause, Maryland could pass such a statute and make it apply to federal law enforcement officers. Could you try to elucidate why you think we could do such a thing?
I don't think Maryland could pass a state law prohibiting federal law enforcement from enforcing federal immigration law.
Fine. Well, if that's the case, again, I don't like racial profiling, but if that's the case, how can we pass a law which says that not only Maryland law enforcement officers may not engage in racial profiling, but also federal law enforcement officers, if they're here in Maryland, making arrests with or without warrants for violation of the United States Code, how can we prevent them? How can we pass a state law which applies to federal law enforcement officers and says they can't engage in racial profiling if it's in the context of doing their federal duties?
I think that's a separate, whether Maryland could enact such a general prohibition is a separate supremacy clause question from whether it could enact the other one that you.
Well, they're both the two laws. If Maryland, you've conceded that Maryland could not enact a law applicable to federal officials and say you can't arrest illegal immigrants.
Senator.
But you think that Maryland can enact a law applicable to federal agents that says that you can't engage in racial profiling, assuming that you contend that you are making an arrest with or without a warrant for violations of the U.S. Code. And I don't understand. It seems inconsistent to me. Why is the one a violation of the supremacy clause, whereas the other would not be?
Because this aspect of the supremacy clause analysis is now in flux, right? We have an administration that is acting in ways that many states find unacceptable, and so states are passing laws that attempt to, in some way, limit federal behavior.
I can certainly appreciate that. We have a number of those bills before us this year.
I understand, and so whether.
Just hold up, just real quick. Let's just calm down, let the witness respond to the question, be responsive.
I don't want to be gavelled.
I don't know what that means, but.
Go ahead, finish.
My only point, Senator, was that the analysis of the supremacy clause question that you're asking about whether if this bill were interpreted to allow a state cause of action against a federal official directly for violating the state's racial profiling law is a different question and a different analysis than whether the state could directly prohibit a federal official from enforcing federal immigration law. The contours of this reverse federalism, the contours of the scope of state authority to limit law enforcement generally in its state is going to be contested and is in flux. I can't give you a definitive answer to your question. But independent of all that, as Professor Graber said, and I think what the intent of this bill is clearly to do, the state can restrict the ability of federal law enforcement officials to borrow from state law in performing their functions. On that, I think there is no possible dispute. And in order to do that, the law enforcement officer has to be defined the way this bill defines it. Because otherwise, they would be excluded from the ambit of the state law at issue here, and therefore would not be bound regardless of the legislature's desire to do so.
We have a similar bill that was introduced earlier to this one called the No Kings Act. Are you familiar with that?
I'm familiar. I mean, I know I've read the bill. I know the bill exists.
So just to come back to what I said earlier, we have a number of bills this year that have been introduced that have responded to the situation with ICE by trying to either criminalize or subject to civil liability federal agents here in Maryland, with ICE agents, who are doing what they believe is executing the responsibilities of their office. But politically here in Maryland, that's unpopular. This is one of them. And my concern is that inadvertently perhaps, but nonetheless really, all of these bills are constitutionally suspect because they go against Supreme Court decisions in the past which have validated the supremacy clause of the U.S. Constitution. And I think, and my understanding is what you're saying is because of the actions of this federal administration, the courts may decide to revisit those prior Supreme Court decisions and reinterpret the supremacy clause in a different way?
No, if that's what I conveyed, then I spoke poorly. I do not present myself to you as a supremacy clause expert, but my understanding of the supremacy clause doctrine is that long prior to Bivens, from the earliest time in our nation's history, federal officials were subject to state law. And those, that has not been necessary to revisit for a very long time, both because of the Supreme Court's decision in Bivens to create a direct cause of action against federal officials under the U.S. Constitution, which more recent courts have now completely undermined to the point of non-existence, because of the creation of the Federal Tort Claims Act, which allowed a very limited set of claims in a very limited set of circumstances with all kinds of other restrictions. And so all these old precedents are now being resurrected, revitalized in light of this new federalism debate in our country. Can anyone conclusively predict what this Supreme Court will do with those precedents? No. Is there a more than good faith argument that laws like this are, and the No Kings Act are perfectly permissible? Absolutely. But again, what I want to emphasize.
But in order, let me just interrupt you, and then we'll bring this to a close. In order to validate this, or this as well as the No Kings Act, the Supreme Court, and it would certainly go up to the Supreme Court, will have to overturn Bivens and also hold that this Federal Tort Claims Act has been supplanted by these new state laws like this one, if we pass it. Isn't that correct?
No, that's not correct. The court would not have to overturn Bivens because Bivens was a direct, a judicially created federal cause of action against federal officials. What the No Kings Act does is creates a state cause of action against both federal and state officials for violations of federal law. And I mean, I don't want to rehash the entire debate and discussion about the No Kings Act. I know you all have considered that. The point I'm making about this bill is that the federal, in order to do the most minimal thing that this bill does, which is ensure that when federal officials borrow state law to perform their federal duties, they are bound by state law, the definition of law enforcement officer has to be what it is in this bill.
Okay. Once again, let me emphasize that the second half of the bill has nothing about borrowing state law. But I've got my questions answered. Thank you very much.
All right, seeing there are no further questions for this panel, thank you all very much. All right, is Neil Franklin here? Gina Amar? Sean Link? Tatiana Santos?
Good afternoon. My name is Rina Amar. I am a staff attorney at We Are CASA. We Are CASA is proud to offer our support for SB 854 today. We Are CASA engages with tens of thousands of Maryland residents every year. This engagement includes providing approximately 1,800 human services every month, including civil legal support and social services to those detained by ICE through our 24/7 hotline. Over the past 4 decades, we have seen firsthand how racial profiling harms our communities. Last fall, in Vasquez-Perdomo versus Nome, the U.S. Supreme Court essentially sanctioned the harms and abuses of racial profiling when Justice Kavanaugh issued an opinion justifying the practice. But the experiences of Black and brown people show that taking the guardrails off law enforcement means more will be hurt or killed. While Black people make up 13.4% of the U.S. population, 22% of people killed in police shootings are Black. 1 out of 3 Black boys and 1 out of 6 Latino boys are sentenced to prison during their lifetimes, compared to 1 out of 17 white boys. Most recently, we have witnessed the violent consequences of racial profiling in Maryland through ICE's blatant targeting of residents who ICE perceives to be Latino. We Are CASA responded to the case of a man who was detained by ICE agents at the bus stop in front of our Baltimore office in September. He was beaten by 6 officers and was initially held at the Baltimore hold room in Hopkins Plaza. When he asked why they were taking him, they responded, "Because you're Latino." We also received a report about a Marylander who on his way to work last fall was beaten, detained, and threatened with death. The officer who arrested him told him, "I don't like Guatemalans, and if I want to, I can shoot you in the head." By passing this bill, you take a necessary step to protect all Marylanders' right to be free from racial profiling by law enforcement. We ask for a favorable report. Thank you.
Good afternoon. My name is Tatiana Santos, and I am a resident in Frederick, Maryland. I'm speaking in support of SB 854. For more than a year, we have seen federal agents acting lawlessly as they flood American streets across the country. We've witnessed them abusing their authority as they have engaged in blatant racial profiling, illegal and baseless arrests, and excessive force against people trying to live their lives. In November 2025, I was stopped by local police in Frederick, Maryland, for what the officer told me was expired tags. My tags had just been renewed, and the sticker on the plate read 2029, so the fact that they were expired was disputable. After 15 minutes of an exchange with the officer, it was determined that there was a glitch in the MBA system, and I was given a warning. When I got home and read my warning document, I noticed it listed Hispanic in bold letters under the race section. With a 287G agreement in place at that time, it became clear that I was not stopped for expired tags, but rather for driving while Hispanic. During the days that followed, I was weary of the police. As violence by ICE has escalated over time, I've become increasingly fearful about how my life could be endangered. You see, I also have a hidden disability. I was born with a congenital birth defect called arthrogryposis, and as a result, my knees do not bend. What would happen to me if an officer tried to pull me out of a vehicle and force me to the ground? We have all seen the story of Miss Aaliyah Rahman in Minneapolis. She was carried face down through the street by ICE agents is now unable to lift her arms normally. There's not a day that goes by that I don't think, what would happen to me? Could I be subject to the same type of violence Aaliyah suffered? I support SB 854 because this bill restricts federal agents' abilities to engage in racial profiling or other abuses. I respectfully urge the committee to issue a favorable report.
Good afternoon, Chair Smith and committee members. My name is Sean Link of the Maryland Office of the Public Defender, and I respectfully request a favorable report of SB 854. Racial profiling is illegal, ineffective, and destructive. That has long been true under Maryland and federal case law as an affront to equal protection and the Fourth Amendment. But nowhere does the Maryland Code presently say that, and this bill shores up and fortifies that truth. Especially necessary now amid signals of backsliding from federal courts, which could trigger a legalization of racial profiling in state courts that would be devastating to Marylanders. It's time now to make sure we have our own house in order with affirmative baseline standards for all local police, for federal agents acting under borrowed state authority, and to shore up public trust. This bill recognizes the necessary work ahead. Maryland continues to struggle with severe racial disparities in our criminal justice system. Racial profiling is not the exclusive cause, to be sure, but explicitly banning it is a key step forward. Racial profiling is not effective. Traffic data through 2024 found that police continue to stop and search black drivers more often than white drivers, yet searches of black drivers are actually less likely to lead to an arrest or discovery of drugs or weapons. We've also seen local and nationwide reports of ICE agents chasing after individuals and smashing car windows, interrogating and arresting individuals. This has notoriously happened in Prince George's County to an unintended man. In another instance, a Maryland mother was detained for 25 days despite providing proof of her U.S. citizenship. In a state where over 17.1% of residents are foreign-born, over half of whom are naturalized citizens, racial profiling is offensive and dangerous. But it's not just these extremes. We hear from OPD clients all the time how any stop based on race is confusing, chilling, and stigmatizing. It tells an individual they don't belong, makes them fear and distrust police and courts. I urge a favorable report on this bill.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you all very much for your testimony today. With that, that'll conclude the hearing for Senate Bill 854. We'll now move on to Senator Quarterman, Senate Bill 713.
Thank you. I think I have a witness that might be virtual. Yep. Okay, let's go ahead. Thank you, Mr. Chairman, Vice Chair, members of the Judicial Proceedings Committee. Thank you for the opportunity today to present Senate Bill 713, verdict of not criminally responsible, eligibility for evaluation. In June of 2022, Washington County community suffered a tragic loss when Mark Allen Fry, Charles Edward Minnick, and Joshua Robert Wallace were gunned down and murdered at their workplace by a disgruntled employee. The shooter fled the scene, only to be apprehended following a shootout with Maryland State Police Detective Sergeant Philip Martin, who was also shot and wounded. Fast forward to April 2023, the families of the 3 murdered victims were informed that the killer would not receive any prison time for his confessed crimes. Instead, he was deemed not criminally responsible for his actions, and as such, committed to Clifton T. Perkins Psychiatric Hospital. Then just 2 months later, in June of 23, just 1 year after this horrific event, and again, just 2 months after the individual was committed to Perkins, this individual was given the option to be evaluated for potential release back into the community. He did not contest this commitment at the time. However, he can be reevaluated for release every year. So what this bill does, it establishes that a committed person who was found not criminally responsible for murder in the 1st or 2nd degree is not eligible for discharge from commitment for the duration of the maximum sentence for the underlying crime for which the person was found in CR, beginning on the date the person was committed to the Maryland Department of Health. So last year when we presented this bill, there was discussion on the committee as far as what other states were doing. So we looked into some of that. And this legislation is based on some of those findings. So in Alaska, someone who is found not criminally responsible can be held up to the maximum prison sentence for the original charge. If the charge carries a 20-year max, they can be confined for treatment for up to 20 years. Even if the treatment, quote, works, early release is not automatic. California also ties length of confinement to criminal sentencing. Maximum term of commitment equals maximum prison sentence for the offense. Example, assault with a deadly weapon, 4-year max could equal 4 years of commitment. Again, even if treatment is successful, release is not automatic. I appreciate the opposition from the public defenders. I know that their position in this legislation, there are some constitutional concerns, most notably with Jones versus United States. I'm not the attorney here, but from what I see, Jones in the United States had to do with misdemeanor larceny. This is felony murder, not necessarily apples to apples, but more importantly, it seems like the tenets of that case are more about the individual being held longer than what a criminal sentence would be. This legislation is about providing treatment for the duration of the underlying crime. And clearly, there aren't constitutional issues if some of these methods are being used in other states. The families and victims in Maryland deserve better. It's agonizing for them now to be victimized and relive this horrific experience on an annual basis, knowing that the individual that murdered their loved ones could be released in as little as a few years, even after undergoing therapeutic treatment. We know this is a difficult situation. We also know, though, when something is wrong, and it's wrong that someone could commit multiple murders and then have the possibility to return to society just a few years later. Last year, again, we had a 10-year commitment based on the average stay at Perkins. This year, we looked at some other states. Again, we understand it's a challenging situation if it is structured in a way that, the committee is, wants to work with. We're more than happy to do that. Again, we feel strongly that something needs to be done to strike that necessary balance. So again, thank you for your consideration, and we respectfully ask for a favorable report on Senate Bill 713. Thank you.
Excellent. Thank you very much, Senator. We'll hear from your guest who's joining us virtually, Angela Frey. Welcome.
Yes, I'm here.
Hey, welcome. You're up. Go ahead.
Thank you. Thank you. Thank you, Senator. On June 9th, 2022, a mass shooter took my husband's life and I became the widow of Mark Fry. I'm here today to ask for justice parity. The law should not be more concerned with the future of the killer than it is with the survival and peace of the families left behind. Under current Maryland law, an individual who commits first-degree murder but is found to be NCR can be evaluated for release just 30 days after entering a hospital. This review process is recurring trauma for victims and a gamble with public safety. Senate Bill 713 corrects this travesty. It ensures the evaluation period for the most heinous acts matches the gravity of the crime. If a sane person faces a life sentence for murder, a person found NCR should not be eligible for freedom in a matter of months or a few short years. The health department confirmed that NCR killers are held, on average, less than 10 years. The result is a glaring disparity in justice. Twice we have come before this committee, twice our voices have been disregarded. I'm not seeking reform to punish the killer that you protect. I'm asking that victims receive the same consideration and compassion extended to him. Maryland acquitted him of 33 charges and left us to carry the lifelong consequences alone. I'm entering my 4th year trauma therapy from mental health injuries caused by Maryland and the actions of a killer. I pay for treatment out of pocket because your Criminal Injuries Compensation Board states I'm not a victim and my claims were declined. Despite living with ongoing psychological harm, I continue to work and make choices that do not harm others. Unlike the person responsible, I will never be released from the consequences of his actions. I will carry Mark's loss with me forever. This is a profound disparity of justice. Rebuttals to opposition have been uploaded, and I respectfully request a favorable report on Senate Bill 713. Thank you.
And Ms. Fry, I just wanted from the committee, just thank you for your testimony, and obviously we're terribly sorry for your loss and appreciate your willingness to continue to stay engaged and to be here with us today. So thank you for that. I'm going to turn it over to the committee for questions.
Thank you. I'll do whatever it takes, sir.
I appreciate it. All right, Senator James has a question.
To Senator Quarterman, thank you for bringing this bill back again. I'm probably one of the ones that asked you to do some research. And I am very glad that you did, because this is very helpful in giving us a sense of what other states do. All states are concerned with due process, constitutional right, and the other states have taken a different approach that I think is on balance, particularly when you remember there are victims, and victims are not just the deceased, as this poor widow has said, but the families and the loved ones that go on in perpetuity in this pain and anguish. So I don't know if this bill is the answer, but I will say that I think you're on the right track, and I like to work with you, but I think we might be a little late this year. Because one of the things I don't think we don't recognize when we're helping, when we believe we're helping protect defendants' constitutional rights. We are, in fact, as this woman just testified, also inadvertently perhaps causing emotional trauma on the victims and those left behind who have to relive this. And it's almost as if we're blinded to it. So that's why I want to thank the woman very much for coming in and expressing that opinion. I know exactly what you're talking about. And again, I'd like to work with you, and we'll talk more about the bill. Isn't that so?
Yes.
All right, thank you.
Thank you.
Excellent. Thank you very much for that. All right. Seeing no further questions, thank you, Senator. With that, that'll conclude the hearing for Senate Bill 713. We'll now move on to Senator Reedy, who's here, with Senate Bill 899.
Thank you very much, Mr. Chairman. I got the Bell Atlantic call from the bullpen, and I ran down from my other committee. I was told to get down fast, so I'm here. And I'm glad to be with you this afternoon on legislation dealing with firearm hold agreements and federally licensed firearm dealers. So this was brought to me by some constituents in my district and also some folks from Frederick County, which I'm a member of the delegation of. Senate Bill 8, this issue was brought to me. Senate Bill 899 would grant FFLs, federally licensed firearm dealers, immunity from being held civilly liable for personal injury or death of a person after the FFL returns a firearm to the owner following the termination of a firearm hold agreement. And I'm just going to explain what firearm hold agreements are, because I actually wasn't as familiar with this process as I became looking at the bill. Firearm hold agreements are a very good thing. They're private agreements between FFLs and firearm owners, where the FFL, the dealer, takes possession of a firearm at the firearm owner's request, holds the firearm for an agreed period of time for safety, returns the firearm to the firearm owner in accordance with the terms of that agreement, spelled out agreement. And it can vary for lengths of time or circumstances. These agreements are rare, somewhat rare anyway, but they're a necessary tool for responsible firearm owners who may find themselves having thoughts of harming themselves or someone else. It's the kind of thing we actually want gun owners we want firearm owners to be, is very responsible. And there's been stigma around mental health in our society, period, of course, and we've been working on that in multiple committees for many years. But there are people and I represent a community where many people own firearms it's a family tradition to have a firearm or multiple firearms in their home. And there can be a fear sometimes of seeking treatment for a mental health issue because of the firearm issue. And so these agreements try to help make sure that someone can have a firearm safely stored with someone else, with a FFL, with a licensed firearm dealer, until they're ready to reconsume it. So under current law, if something were to happen after that dealer, that agreement was terminated, it expired, FFLs could be held civilly liable for simply returning the firearm after the firearm agreement expired. The immunity liability does not apply to personal injury or death caused by unlawful contact. Additionally, this bill does not apply to firearm transfers in accordance with 6-234 of the Criminal Procedure Article, which outlines the legal process of a court-ordered firearm transferred after a disqualifying concern. So this doesn't deal with that, with the protective orders or any of those disqualifying ownership concerns. Only deals with these firearm hold agreements that are private agreements. And in my view, it's an effort, and it was brought to me by folks who are just concerned about that loophole, almost like a loophole, that they don't want someone to come later, could even be months, years down the road, and say, well, you surrendered, you gave this firearm back to this person. And so it's just an attempt to tighten that in the law. I am happy to answer any questions and would ask for support from the committee. And I understand the issue of firearms and the sensitivity here. Obviously, I've been on the other side of the issue of Second Amendment issues from some of you on the committee. I think this is an example of trying to be sure we're keeping people covered and being responsible. So happy to answer any questions, Mr. Chairman.
Thank you very much, Senator. Do you want to bring up let's bring up your panel real quick.
Yes.
So let's hear from John Jocelyn, John Weber, and then Mark Pennick is going to be joining us virtually, and then we'll
Good.
open it up for questions. I know Senator Love has a question.
This is the second time I did this. I should have brought them up. I'm
That's all
sorry.
good.
I get
That's
going
good.
and get
They're
excited.
here, so
They're here.
come on up.
Come on up, please. Thank you.
You can put them in the room, yeah. They're going to be here for my bill, too, just on the other side. So it's good. It's good.
Correct, yes.
It's good.
Pro and con. John Weber, NRA. I think it's a very straightforward, logical bill. Once an agreement ends, then it should end. So we're fully supportive of this and appreciate its introduction.
Good afternoon, Mr. Chairman and members of the committee. My name is John Jocelyn, speaking for 2A Maryland in support of Senate Bill 899. I am a Maryland qualified handgun instructor, and in my written testimony on page 2, you will see a snippet from one of the pages of the Maryland State Police Carry Permit Training course. And in the square cloud, you'll see language that indicates that if you are experiencing a health crisis, a mental health crisis, that you should consider storing your firearms. The link in that cloud you'll see where it goes to is on page 3, and it shows an organization that has identified some dealers who will store your firearm. So this bill really enhances what we already have in the training, in that it will now encourage dealers to provide this service, because this bill will shield them from liability should something untoward happen subsequent to the return of the firearm. We think it's an excellent piece of legislation. It's simple, it's easy to understand, and we ask for a favorable report.
Now going to hear from Mr. Pennick, who is joining us virtually.
Thank you, Mr. Chair. Mark Pennick, President of Maryland Show Issue. We also stand in support of this bill. I will say that in my personal capacity, I represent a number of federal firearms licensees and dealers who are very reluctant to undertake these sort of voluntary agreements because of the potential for litigation, civil and criminal, against them. Dealers are heavily regulated in this state and are often subjected to accusations that they have contributed to harm caused by firearms that they sell. I would suggest that there is on subpart 2, sub C, where there's an exception from the immunity for injuries or death caused by the unlawful conduct on the part of the federally licensed dealer. I can drive a truck through that exception because unlawful conduct could include civil conduct simply as negligent. The allegation for negligence is easy to make and hard to disprove. The death that's caused by such conduct is not limited to either proximate cause or otherwise, so I would suggest that the bill be amended to a death proximately caused by criminal conduct on the part of the federal licensees. With that amendment, I would heavily support this bill. Thank you.
Excellent. Thank you very much, Mr. Pennick. We have seeing no questions from the committee. That will conclude the testimony for Senate Bill 899. Thank you very much, Senator Reed. Thank you to the panel. All right, we'll now move on to Vice Chair Waldstreicher with Senate Bill 830.
Well, thank you, Mr. Chairman, members of the committee. This bill deals with our handgun roster board. And just a quick history of the board. In the 1980s, a number of kind of fly-by-night handgun manufacturers showed up, and they were selling dangerous weapons, dangerous handguns that we affectionately call Saturday night specials. You don't see that anymore. The industry has consolidated, but maybe if you watch movies from the late 70s and 1980s, you'll see these very cheaply made pistols. They weren't dangerous because they were guns. They were dangerous because they were poorly made and oftentimes would fire without a trigger pull and the like. And so we created something called the Handgun Roster Board as a consumer protection method to make sure guns that were cheaply made or otherwise especially dangerous could not get into the flow of commerce in Maryland and threaten our communities. After the Heller decision, which held that there was an individual right to self-defense, but create an exception for especially dangerous weapons, the Handgun Roster Board fulfilled our duty in defining what a handgun is and is not under our legal definition. As you might imagine, we don't use magic words in Annapolis. You can't just call something a handgun that turns out to be a assault rifle that's banned under the assault rifle ban that we implemented under then Senator Raskin in 2013. And so the Handgun Roster Board assures that the handguns that are being licensed for sale in Maryland are in fact compliant with law. But so we have an issue with how the board is working. The problem in front of us is that this citizen volunteer board is poorly positioned to fulfill the statutory obligations for which it was created. The first people to admit this problem are the board members themselves. They are civilians. They are volunteers. They cannot engage in legal sufficiency analyses, although we currently require them to. They cannot engage in consumer protection analyses, even though we currently require them to. And so what is the solution to this issue? That's what the bill in front of you attempts to solve. It does three things. First, it places the legal sufficiency analysis that is required of the board with experts in legal sufficiency analyses, the Office of the Attorney General. To be clear, this bill doesn't expand the analysis. In fact, it does the opposite. It creates an objective, mechanistic legal review in an office with the experience to conduct those analyses. Two, it creates a robust consumer protection test. Robust testing is necessary to effectuate the legislative purpose of the current law. This testing protects our constituents and our communities. We know that more robust testing increases workload on Maryland State Police, which is why we specifically allow MSP in the bill to contract with technical experts to assist with the testing. Other states have taken this route, and it has worked flawlessly there. Third, the bill allows for retesting of handguns. This is 100% normal in every other industry. Automobiles are the best example. NHTSA tests vehicles for safety, and if they pass, the vehicles can then be sold to the public. But sometimes dangers appear later, and NHTSA can issue recalls or even do not drive orders. Just last week, Mr. Chairman, you would probably like to know this, Jeep issued a do not drive order for some of their vehicles that have defective airbags. The same is true with handguns. Upon complaint, MSP must have the statutory authority to retest handguns that are alleged to be defective. This bill gives them that authority. So if the OAG runs the legal sufficiency analysis and MSP and its vendors run the consumer testing, what then is the purpose of the board under the bill in front of you? In the bill, the board becomes just like any other board in our state. They have oversight authority. That's how almost every other board operates. The mortuary board doesn't inspect crematoriums, the staff does that, and the mortuary board oversees the staff. The Sentencing Commission doesn't provide independent sentences for criminal defendants. They provide broader sentencing recommendations and study trends and issues. So in sum, this bill will professionalize our legal sufficiency requirement, uphold our consumer protection obligations, allow for retesting like any other industry, and normalize the board to make it analogous to every other state board. I ask for a favorable report.
Good afternoon. Karen Herron, Executive Director of Marylanders to Prevent Gun Violence, here in support of SB 830 to modernize Maryland's handgun roster process. More than 35 years ago, this body created the handgun roster as a consumer protection tool in response to a market flooded with cheap, unsafe firearms. The goals were simple: create a statutory compliance checkpoint and a consumer safety safeguard. But firearm industry in 2026 is very different than it was in 1988. We now see high-capacity semi-automatic handguns, modular and polymer designs, firearm kits, rapid-fire modifications. Yet the roster process has not kept pace. For years, most firearms have been added with little or no meaningful review. Problematic and at times unlawful firearms have made it onto the roster, and once they are on, there is no clear mechanism to revisit those decisions. The result is a system that legitimizes firearms that may not actually comply with Maryland law. SB 830 fixes that. It assigns legal review to the Attorney General, the state's chief legal authority, to determine first whether the firearm is lawful under state and federal law. It establishes real product safety testing standards. It creates a pathway to reassess firearms already on the roster if new information emerges. And finally, it clarifies that the board's role is procedural oversight and public accountability. Importantly, this bill does not expand the roster, and it does not change Maryland's underlying prohibitions. It simply ensures that our existing laws function as intended. We respectfully urge a favorable report.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. My name is Kelly Roscom. I am the Director of Law and Policy at the Johns Hopkins Center for Gun Violence Solutions. I am an attorney, and I have spent well over a decade drafting, analyzing, and advocating for gun violence prevention legislation. This testimony represents my personal opinion and does not necessarily reflect that of Johns Hopkins University. Maryland law prohibits the manufacture, sale, or offer for sale of any handgun that is not listed on the state's handgun roster, which is compiled and maintained by the Handgun Roster Board. Though the Handgun Roster Board is directed to evaluate concealability, ballistics accuracy, weight, quality of materials, quality of manufacture, reliability as to safety, caliber, detectability by standard security screening equipment, and utility for legitimate sports activities, self-protection, or law enforcement, the statute provides no definitions, benchmarks, or weighting for any of these factors, or really any guidance in how to determine how any of these weigh into whether or not to add a handgun to the roster. Additionally, there exist different definitions of handgun throughout the Maryland Code. Handgun is defined for the purpose of the Handgun Roster Board as a pistol, a revolver, or any other firearm capable of being concealed on the person, but not a shotgun, a rifle, a short-barreled rifle, a short-barreled shotgun, or an antique firearm. However, elsewhere in the code, in the criminal code, handgun is defined differently to include a short-barreled shotgun or short-barreled rifle. Although members of the Handgun Roster Board often attempt to read and apply Maryland law, most lack formal legal training, and as a result, sometimes misinterpret these statutory terms and apply them incorrectly, adding firearms that were never meant to be on the Handgun Roster Board. We ask for a favorable report of SB 830, which would ensure expert legal review and consistent and objective safety requirements. Thank you.
Good afternoon, Chair and members of the committee. My name is Kim Dennis, and I'm a resident of Baltimore City. I'm here today as a gun owner, a citizen member of the Handgun Roster Board, and most importantly, as a survivor of gun violence. I agreed to serve on this board because I see the impact of gun violence in my community every single day. For me, this isn't just theoretical, it's personal. My nephew, Andrew Zachary, was murdered on January 15th, 2017 in Baltimore City, and his case remains unsolved to this day. I took this appointment seriously because I wanted to be part of the solution for a city that has lost too many of its children. I have dedicated myself to this role. In my time on the board, I've missed only one quorum, and that was to attend my niece's high school graduation. It was a bittersweet milestone, and that was because knowing that her big brother should have been there to see it. When I first joined, I didn't know what to expect. Maybe a manageable workload, perhaps a few handguns to review each session. The reality has been a wake-up call. We are faced with a massive volume of petitions, often 50 or more every single quarter. Despite this heavy responsibility, there was no formal or informal training provided to help me navigate this volume or the complexities of the petitions. I was essentially dropped into the deep end of a very high-stakes pool. I have seen the inner workings of this process firsthand, based upon my experience on the front lines of the board. I do believe the reforms proposed in this bill will work. They address the operational realities we face, and they provide the meaningful change our communities in Maryland actually need. I urge a favorable report on this bill. Thank you for your time.
All right, before we switch to, we have a couple of other guests joining us who are in support of this bill, but wanted to make sure that the committee has an opportunity to ask this panel a question. And Ms. Gretton, thank you for your testimony and solid for your laughs. Senator West, go ahead.
Thank you, Mr. Chair. I have a lot of questions, but I'm going to limit them just to two areas. If I could talk to the sponsor for a moment. Both the Department of State Police and the Attorney General talk about the practical difficulty that they would have in complying with the part of the bill that requires them to go back and retest the 5,083 guns which are currently permitted on the list. I could go into details, but the state police say they lack the facilities, capacity, and records needed to conduct this testing. The Attorney General talks about, he has basically the same problem.
Sure. Yep.
And the cost of doing that is estimated by the state police to be over $17 million, nearly $18 million. The fiscal note says it would be $10 million in fiscal year 2027, $10.2 million in fiscal year 2028, and at least $1.4 million annually thereafter. Have you gotten permission from the Budget and Tax Committee to spend that much money on this effort?
So good question. So we have been working closely to craft amendments to address the concerns of MSP and OAG, who are obviously core to the bill. There have been some miscommunications earlier in the drafting process that we have now ironed out. And so I don't come to you with a reprint because well, it's a long story. We will have a reprint for you shortly that addresses those concerns, both the operational concerns and the fiscal concerns. The House has already begun the process of putting the bill into that shape.
Okay, and along the same lines, my second question relates to the various testing procedures that the bill seems to require, including 500 continuous rounds of live fire function testing and drop testing. It says the Maryland State Police currently lacks the specialized equipment required to conduct drop testing. Procuring it would be costly, and the firing of 500 continuous rounds per weapon is also going to be time-consuming and costly. Are those subjects going to be addressed in your amendments?
They are, yes. So that will be addressed through amendment, and we acknowledge those concerns. Conceptually, what you should know, though, is that, as referenced, the bill also allows MSP to hire neutral vendors who do have this capacity to conduct that testing. Other states have adopted that model, which allows the regulator to bring in outside people who do this every day for a living. And so while the short answer is yes, we're going to address that through amendment, the House has already begun that process. The more conceptual thing is MSP alone will not be responsible. They are allowed to bring in other vendors to assist with that testing.
Okay, and if I could, Mr. Chair, one more question before I finish. In the bill, the testing is required to include concealability, ballistic accuracy, weight, quality of materials, quality of manufacture, reliability as to safety, caliber, detectability by standard security equipment, utility for legitimate sporting activities, self-protection, law enforcement. Do you have any information which would lead us to believe that of the 5,083 weapons already permitted, that any of those weapons do not comply with these testing requirements?
Well, some of this language is going to come out. Some of this is actually a repeat of current law, but we're going to tighten that language and make it more clearly objective.
Okay, so we'll wait to see. It sounds like the amendments are going to significantly modify the bill. We'll have to wait to see them.
I think that's right.
Okay, thank you.
Thank you.
All right, thank you very much. Further questions from the committee for this panel? All right, thank you, Mr. Vice Chair. Thank you all. Thank you, the panelists. And if you are a Senate page and would like to come sit up on the side here, you're welcome to do so. We'll even allow the House pages to do it as well, but you can come on up. All right, so let's hear from Aaron Earp. Is Aaron here?
Yes, I'm here.
Okay, excellent. And then Steve Lindley. Okay. Aaron, go ahead. You're up. Welcome.
Good afternoon, Mr. Chair, members of the committee. My name is Aaron Erb. I'm a senior policy counsel for the Giffords Law Center and also a resident of Calvert County. Thank you for the opportunity to testify today in support of SB 830, the reform of the Handgun Roster Board. This bill makes important changes to ensure that handguns approved by the board are safe and are importantly handguns. As previously mentioned, there are a couple of different definitions of handguns in Maryland law. The definition of handgun in the criminal code explicitly includes short-barreled rifles and shotguns, unlike the federal definition, which does not include them. Now, the current federal or current state handgun roster board statute has a separate definition in its text, but it's not actually the one that's used. The criminal law definition is what's referenced in section 5-402, which is just one section after the where the definition, the different definition is. But in this bill, as you'll see, I believe in the amendment, it would apply the definition that's already in the statute to the parameters of the roster board, which is the definition that excludes short-barreled rifles and shotguns from the definition of handguns. This is critical because in recent years, petitions before the board, quote, in great numbers, have come to approve short-barreled rifles as handguns. And as an analysis by the Baltimore Sun concluded that between 2018 and 2024, 95% of petitions brought before the board were approved, including a number of short-barreled rifles. And so changing this definition and adding in the Attorney General's legal review prior to review by the board will ensure that no additional short-barreled rifles are being added to the roster. This bill will also ensure that the board fulfills its role in protecting consumer and public safety. I urge a favorable report. Thank you.
Excellent. Thank you very much. All right, Steve, you're up. Welcome.
Thank you. Good morning, Chair and committee members. Thank you for the opportunity to testify today. My name is Steve Lindley, and I am a law enforcement professional with over 28 years of experience, including more than 8 years as the chief of the California Department of Justice Bureau of Firearms, where I oversaw statewide firearm regulation programs and enforcement. I currently serve as a senior advisor to the Brady campaign to prevent gun violence. I'm also a high school teacher. I'm here today to express my support for Senate Bill 830. This bill presents a thoughtful, structured approach, ensuring that handguns available for sale in Maryland meet appropriate safety, legal, and functional standards. It strengthens Maryland's existing handgun roster process by establishing a clear, accountable framework. It requires the Attorney General to conduct a legal review of each firearm before it is approved, and for firearms to undergo objective testing to ensure the functionality and safety, reliability, something that the firearm industry does not do. This bill incorporates rigorous testing standards, including live fire reliability testing and drop safety evaluations to ensure that firearms do not unintentionally discharge and meet minimum performance thresholds. Again, something that the firearm industry does not do. When done correctly, these systems help ensure that firearms entering the marketplace are safe, reliable, and lawful while providing clear guidance to manufacturers and regulators alike. Thank you for the opportunity to speak today. I ask for your favorable support, and I'm open to answering for questions.
Excellent. All right, thank you very much. Questions from the committee? All right, seeing none, thank you both very much. We'll now switch to the guests who are signed up in opposition. Is Kim Dennis here, John Weber, and then John Jocelyn, come on up, and then we'll hear from Mr. Pennick.
Senator, I think Kim Dennis accidentally signed up the opposite way. She's the one who has to.
Thank you. Chair Smith, members of the committee, my name is John Weber, and I represent the National Rifle Association and our members in Maryland. The NRA is opposed to Senate Bill 830. This would reform Maryland's handgun roster board process in ways that introduce political bias, arbitrary decision-making, unnecessary bureaucracy, added cost, and no clear evidence of public safety gains. This will shift the core authority of the Attorney General, an elected official, for legal reviews, potentially injecting partisan politics in what should be a neutral technical process. This change risks turning roster approvals into a tool for advancing ideological agendas, such as restricting compact or innovative handguns without enhancing safety. The new testing requirements will add significant expense, burdening law-abiding gun owners. Petitioners must also navigate additional demands, limiting resubmissions, creating massive hurdles for individuals who follow the law while doing nothing to address actual criminal misuse of the firearms. These reforms impose real costs on state resources without proven benefits. The AG's office, MSP, and board will need to handle increased reviews, testing coordination, online publications, and confidentiality protocols, pulling staff from other duties. This will strain budgets and operations, diverting funds that could actually support crime prevention. This bill will also limit Maryland's access to safe, reliable handguns for self-defense and sport. It does not fix a documented safety gap. It only makes the process more cumbersome and susceptible to abuse. For these reasons, the NRA is opposed.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for 2A Maryland in opposition to Senate Bill 830. House Bill 1131, the Saturday Night Special Bill in 1988, was what launched my 2A activist career. This bill replaces the board with the Attorney General. The board is reduced to performing clerical activities. It has oversight but no enforcement authority. The characteristics the Attorney General is required to consider are listed but not defined. If the Attorney General declares a firearm to be legal, it then goes on to testing with the Maryland State Police, who we know don't have the capability. They would have to subcontract it at $3,500 per firearm. The testing parameters are listed as to what they test for, but there are no specifications. Drop from various heights on various surfaces. Undefined. The 500 round test, many firearms were never intended to fire 500 rounds without cleaning, especially those that are built to high precision tolerances. The bill allows for confidentiality, which is anathema to transparency. The AG has the authority to declare some communications to be sealed. The board is required in 2 months between October 1 and January 1st to come up with a fee schedule. It's doubtful that the member of the board have the experience or the expertise to properly evaluate what the fee schedule should be. We believe that this bill is cumbersome, unworkable. There are many, many other things that I have in my written testimony. We ask for an unfavorable report.
Excellent. Thank you very much. All right, Mr. Pennick, you're up. Mr. Pennick, if you could unmute, we're going to ask to unmute. We'll restart your time.
Yeah, I'm sorry.
No worries.
Thank you, Mr. Chairman. Mark Pennock, President of Maryland Shall Issue. I join in the opposition to this bill for many of the same reasons that have already been articulated. It does indeed place a state elected official in lieu of the board, and thus opens the board up to the accusation of political activism. There is no trust in the firearms community in the Attorney General's ability to administer this bill fairly. Full stop. I join in also the point is that the criteria for testing are ill-defined and are subject to completely arbitrary interpretations that could vary from case to case, from firearm to firearm. There is no limitation. I note that the bill is a work in progress, so it's hard to testify. There are over 5,000 guns on that roster now, and the state attorney general is supposed to arrange for the testing of all 5,000. That's an impossible task. Certainly cannot be completed within 45 days without a massive investment of funds. The state is already in financial straits. I see very little reason for this body to sanction the expenditure of millions and millions of dollars on what is apt to be useless testing and review of something that's been on the roster for years. I would urge an unfavorable report. The bill is unworkable. Thank you.
Excellent. Thank you very much, Mr. Pennock. Questions from the committee? All right, seeing none, thank you all very much. With that, that'll end the hearing for Senate Bill 830. We'll now move on to Senator Sidnor with Senate Bill 752.
All right, Mr. Vice Chair and committee, good afternoon. In 2025, the Maryland Equitable Justice Collaborative, a partnership between the Office of Attorney General and the Office of Public Defender, published this report examining systemic factors contributing to the overrepresentation of Black Marylanders in the state's correctional facilities. One of their 18 recommendations was to conduct a qualitative and quantitative analysis of each step in the criminal legal process, from arrest to sentencing and parole, to understand the impact of racial and geographic disparities in Maryland's adult prison population. In 2023, the Maryland State Commission on Criminal Sentencing Policy acknowledged, and Senator West and I both are members or commissioners on that commission, it acknowledged its limited ability to assess racial disparities in sentencing. Racial inequality in the criminal justice system reflects cumulative disadvantage related to various stages of criminal processing, including police stops, arrest, charging, incarceration, and community supervision was that response. Now, while Black residents make up 31% of Maryland's population, 71% of the Division of Corrections inmate population is Black. In 2019, the Justice Policy Institute reported the proportion of Maryland prison population that is Black is more than double the national average of 32% and higher than any other state. Systemic issues like those reflected by this staggering disparity cannot be resolved by looking at one step of the process at a time. To understand how and why disparate outcomes occur and how to fix them, we need to look at the entire system and how it works as a whole. In a complex system, there are dozens of opportunities for bias, mistake, and discrimination to enter the equation. With each additional step, those injustices, even the smallest ones, are going to be compounded until one day we lead the nation in a disproportionately incarcerating black people. This is unacceptable, and we need to address it. Senate Bill 752 creates a commission to study these disparities. The commission will be made up of stakeholders from across the justice system, members of the General Assembly, and they do not need to be you. I know it's an election year and we have this thing on commissions, and I'm willing to serve. And as well as the Public Defender's Office, the Attorney General's Office, the courts, the State's Attorney's Office, and members of the public that demonstrated an interest in advocating for improvements to our state justice system. Members of the commission will be charged with studying and making recommendations to address topics like disparate treatment at each step of the criminal justice system, mandatory minimum sentences, alternatives to retributive punishment, and felony murder rule and data collection gaps. This commission, although not a complete solution, is a vital step in understanding the vast disparities in our state justice system. For these reasons, I ask for a favorable report on Senate Bill 752 and hand this over to my panel.
Good afternoon, Chair Smith, committee members. Phil Karoum speaking for the Maryland Alliance for Justice Reform today, not for the Maryland Judiciary. I'd just like to emphasize, I'm not going to repeat my testimony and try not to repeat what Senator Sidner said. This is not a small problem. It's not a new problem. It is a problem that has been existing in the state of Maryland and large parts of the country for many years. In 2019, there was a insightful report by the Justice Policy Institute, which recognized that in Maryland prisons, those who receive sentences of 10 years or more are disproportionately Black in Maryland more than twice the national average, and Maryland's disproportionate sentencing of long incarceration for Black Marylanders is higher than any other state in the United States, at least as of 2019, higher even than Mississippi. The Sentencing Guidelines Commission, as Senator Sidner referenced, has looked for the same effect and has found it around the state. The mean offender score under the sentencing guidelines for Black offenders is 22% higher than the mean white offender score, and yet the overall non-suspended sentence for Black offenders is twice that of whites. Why is that? We don't know because we haven't studied it. The Sentencing Guidelines Commission reports that there's great disparities between one county and another. Why is that? We don't know because we haven't studied it. We strongly urge that the committee support the study that is needed with SB 752. Thank you.
Good afternoon, Chair, members of the committee. Heather Warnken. I serve as Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law. I also served on the Executive Committee of the Maryland Equitable Justice Collaborative and on numerous MEJC working groups. Here in strong support of SB 752. So this committee understands well that Maryland has made meaningful strides in justice reform over the past decade, but racial disparities persist, and in some cases, they have worsened. So this is an important point because while reform and racial equity are often seen as intertwined, the reality is more complicated. Some efforts that have successfully reduced the size and the reach of the system have also made it more likely that those who remain ensnared in it are Black. Although Marylanders make up only 30% approximately of the state's population, they account for 51% of arrests, 59% of the jail population, 71% of the prison population. I don't need to repeat all of the statistics, although they're definitely worth repeating, but I will underscore that, again, some of this is getting worse, that recent data is showing growing inequities in not just the sentencing, as Judge Karoum mentioned, but pretrial detention as well. We have clear evidence that these disparities remain entrenched, even as overall arrests, incarceration, and community supervision populations have declined. We have to take steps to better understand why. This bill does exactly that. It will deepen our understanding of these disparities and support research-informed, actionable policy solutions. The Commission will also examine critical decision points across the system to target equitable approaches and identify areas where consistent quality data collection is lacking and where we need additional investments in our research infrastructure to further these goals. Lastly, I'll just say by passing this bill, Maryland will join a growing list of states that have undertaken similar efforts, which I'm happy to discuss. We urge a favorable report.
Good afternoon again, Chair Smith and committee members. My name is Sean Link from the Maryland Office of the Public Defender. I respectfully request a favorable report on Bill SB 752 as a step toward breaking the cycles of racial disparities and mass incarceration. In a fair and equal system, justice would be race neutral. Tragically, that expectation here today is far from the reality. As Senator Sidnor and others have commented, 2019 reports showed Maryland leading the nation with extreme racial disparities, and unfortunately since then, data appears to show that the issue has worsened. Although Black individuals now represent an estimated 31.6% of the state's population, they make up 72.7% of the incarcerated population per 2025 data. This number remains nearly double the national average, highly alarming on its own, on top of signaling that apparent increase over a few years. The percentages of Latino and Asian inmates in Maryland DOC have also increased over that period. Disparities exist at every stage. Black and brown individuals are more likely to be denied bail and ultimately receive higher punishments for similar offenses. While each of us at OPD advocates for fairness for each individual client, it's clear that broader proposals for systemic reform and relief are necessary. This proposed commission's task is broad, but it's crucial, taking a data-driven approach to examine disparities at each stage of the criminal justice process, from policing through parole. This is vital for fairness and rehabilitation to each individual. Smart reforms could reduce mass incarceration and recidivism rates, thus ultimately saving taxpayer money while increasing public safety. And while this does remain a nationwide concern, that level of disparity being unmatched in Maryland is of a special concern. OPD urges a favorable report on SB 752 to move us closer toward equal justice under law. Thank you.
Thank you very much. Senator West. Thank you. All right, hold on. Is there another witness here signed up?
I don't think so.
Okay, sorry. My apologies. Go ahead. Senator West.
So I totally agree. This has now been, this is my 8th year. We have heard similar statistics throughout the years. I don't think I've ever heard it quite as high as 72.7%. I've heard it sort of averaged around 70%, but the statistics are shocking. But I think it's critical that this study not be conducted with blinders on. For example, the word victim never appears in the bill. Can you point, and if, for example, we were to learn that 72.7% of the victims of crimes were Black, it would be more understandable why 72.7% of the people in prison and jail are Black. But the word victim is never mentioned in the bill. Can you point to language in the bill which will assure us that this study will include a study of the victims and other possible causes of these shocking statistics beyond the fact of racism?
You know what? You raise a good point. I don't think that is in, but the professor, she wouldn't, if you don't mind, she'd like to respond to that. We're open to that.
Professor, could you answer that question?
Sure. Thank you for the question, Senator West. This is a very broad charge that this commission has. So number one, I would argue that there's a lot of latitude to further refine the long list of issues in the criminal justice process that impact the racial disparities in the state, how crime victims are treated, and I've been in front of this committee a number of times talking about that, also is rife with racial disparities. I also want to talk about one of the areas of the MEJC report that really connects these dots and which this commission is really meant to pick up on, which is that we also have research pointing to the fact that when the victim is Black, the sentencing is more lenient And this is the type of other layer of bias that this commission is meant to pursue. Because as you've said, we have heard these statistics over and over and over again. We need to understand why from multiple angles. So I would argue this commission very much should look at victim issues, especially because there's a false binary between who are victims and who are people ensnared in the system, as our MEJC report also looked at length.
Okay. Let me just say that I hope we pass this bill. I intend to vote in favor of it. But when the report comes out, if the report doesn't mention such considerations as victims, I will be very disappointed, because in my view, the report will not be as valuable to us as if all elements that might factor into these statistics are taken into account.
Yeah, I couldn't agree more. Thank you, Senator.
Thank you.
All right, thank you very much, Senator. Further questions from the committee? All right, seeing none, thank you, Albright. Thank you, Senator. Thank you to your panel.
Thank you.
With that, that'll conclude the hearing for Senate Bill 752. We'll now move on to Senate Bill 692, our final bill of the day. Never too late to come on board. Hey, how are you? All right, Mr. Vice Chair, members of the committee, Senator Smith here to present Senate Bill 692. In doing some research for this bill, we looked at other industries that require training in order to conduct business in Maryland, and something that we found was that in order to sell cannabis, for instance, you have to have annual training. In order to sell tobacco and alcohol, you have to go through training as well. But to sell firearms in Maryland, there is no such requirement for any sort of annual training or initial training. Obviously, you have to be cleared to enter the profession and you have to be subject to inspection, but there's no annual training requirement. And so Senate Bill 692 seeks to set forth a basic framework of training for those who deal directly in the sale of firearms in Maryland. Gun violence in our nation and throughout our state are obvious significant problems. As a state and as a committee, we have taken significant steps to curb gun violence in Maryland. And this bill represents a simple and small step forward to ensure that dealers are knowledgeable about the laws that govern their business and are able to prevent bad actors from engaging in fraudulent transactions. And doing more research for this bill, I found that about 440 FFLs would be impacted by this bill. And to put things into some perspective, there are about 112,000 guns, 112,000 guns that are sold in Maryland every single year. So having people that are at the point of sale have some basic level understanding of the laws that govern their practice and their industry is extremely important. And even when properly licensed firearm dealers are adhering to the law and acting in good faith, we know that 48% of crime guns recovered in Maryland were sold by a Maryland dealer. Straw purchasing is obviously a significant problem in Maryland. More than two-thirds of firearm dealers experience attempted straw purchases throughout their course of operation a year. And we saw this take place here in Maryland. Just last year, Attorney General Anthony Brown, alongside his counterpart in Washington, D.C., sued 3 Maryland firearm dealers who sold guns to a straw buyer who then trafficked those weapons into Washington, D.C. So this bill is a straightforward way to prevent the movement of guns from licensed dealers to bad actors. Leaning on the ATF, the Federal Bureau of Alcohol, Tobacco, and Firearms, they've called firearm dealers the first line of defense against straw purchases because they can prevent these transactions by looking out for red flags. And what this bill does is seeks to have some semblance of training and understanding of those laws. By training firearm dealers on common signs of straw purchases and other fraudulent activity, dealers will be able to avoid transactions that result in dangerous people obtaining guns. The ATF, again, has said that the trained firearm dealers can significantly reduce the risk of straw purchasing. Trainings will also ensure that dealers have up-to-date information on state and federal laws governing their practice. And even though an applicant for a firearm dealer must complete an orientation, again, as I mentioned at the top of my presentation, there is no annual training requirement or semi-annual training requirement. A number of states have also moved forward in this posture. Colorado, Illinois, Connecticut, Massachusetts, New York, California all have implemented training requirements for licensed firearm dealers, and I think Maryland should do the same. The training requirements are especially important now as federal oversight over the sale of firearms in Maryland has been minimal. In 2024, Maryland was inspected less often than all but one region in the country by the ATF, a result of federal action. So what does the bill do? The bill does two things. It requires the Secretary of State Police to approve an online training course, 25 questions, multiple choice exam that provides instruction on the following: state and federal laws regulating the transfer of firearms and ammunition, preventing and reporting to law enforcement the theft of firearm ammunition, teaching customers firearm safety, including safe storage and handling of firearms, recognizing and reporting to law enforcement signs of straw purchases, firearm trafficking, fraudulent activity, and an individual who intends to use the firearm for an unlawful purpose, and any other subject that the Secretary deems appropriate. You need a 70% score to pass. You've got to maintain that certificate in the employee file. And the bill has a few amendments which are not before the committee, but I'll explain them. One is that the test would be given semi-annually. This is your suggested amendment, semi-annually. One is that it'll be 25 questions, not 20, 70% passage rate. And then there is another piece that mimics what we have for safe storage, and this is to ensure that there is no admissibility of any sort of running afoul of this into a criminal forum. So it mimics what we have for our safe storage laws. So with that, Mr. Vice Chair, members of the committee, I'll conclude and ask for a favorable report. I'll turn it over to my panelist and stand by for questions. If you come to this,
Thank you, Chair Smith, Vice Chair Waldstreicher, and distinguished members of the committee. My name is Josh Scharf, and I am General Counsel and Senior Director of Programs at Brady. I lead Brady's Combating Crime Guns initiative, a program that seeks to disrupt the diversion of guns from the legal to the illicit market. We proudly support SB 692. Training gun dealers and their employees saves lives. I've seen it up close, having litigated cases on behalf of victims of gun violence against businesses whose mistakes and indifferences led to avoidable tragedies. Gun dealers are positioned as gatekeepers, ensuring that guns are not diverted to straw purchasers and traffickers or transferred to someone who is in crisis. Maryland understands the important role of gun dealers and has set up a state-level system of industry oversight. But one significant gap, however, is the lack of required training for store employees who handle and transfer firearms, as well as the lack of ongoing standardized training for gun dealers. Federal law does not fill this gap, as it neither requires gun dealers to train their employees nor requires standard refresher training. SB 692 will close this gap and help gun dealers and their employees save lives by complying with their existing duty to prevent dangerous sales. And research shows that safe business practices at gun stores leads to significant decreases in crime guns. In 2024 alone, 4,529 crime guns were traced back to Maryland dealers. Required training for Maryland's gun dealers will help reduce these numbers. The communities that are most impacted by gun violence, which are disproportionately Black and brown, are too often expected to solve the gun violence crisis on their own, while little is done to ensure that firearm businesses act responsibly and not supply the illicit market. This bill shifts that burden and focuses on reducing the supply of crime guns. For these reasons, Brady urges a favorable report on SB 692. Thank you.
Good afternoon again. Karen Herron, Executive Director of Marylanders to Prevent Gun Violence, here in support of SB 692, requiring firearm dealers and employees to complete training and an exam on state and federal law and responsible sale practices. Maryland has some of the strongest gun laws in the country, yet a significant share of crime guns are still coming from in-state dealers. In 2024, roughly 48% of crime guns recovered in Maryland were originally sold by Maryland dealers. Maryland dealers also supply a substantial number of crime guns recovered in Washington, D.C., where Maryland was the second leading source state last year. Time to crime data tells a similar story. This measure, the time between a firearms retail sale and its recovery by law enforcement, is widely used to identify trafficking risks. Firearms recovered within 3 years of sales are considered especially concerning. Since 2020, Maryland has seen increases in these low time-to-crime guns, and in 2024, Maryland exceeded the national average for the first time in years. At the same time, federal oversight capacity has been strained by reductions in ATF funding and staffing. That makes it even more important that Maryland strengthen its oversight within our own system. SB 692 is a practical, prevention-focused step. It ensures that dealers and employees involved in firearm sales are trained to understand U.S. and Maryland law, recognize straw purchasing, identify buyers who may pose a danger to themselves or others, and follow clear compliance practices. This is not about punishing responsible dealers. It's about equipping them with the tools they need to prevent illegal sales, protect their businesses, and help keep firearms out of dangerous hands. We regulate professional industries where public safety is at stake. Firearm retail should be no different. I respectfully urge a favorable report on SB 692.
Good afternoon. My name is Ethan Bartlett, and I am an Assistant Policy Advisor for the Johns Hopkins Center for Gun Violence Solutions. I am here today in my individual capacity, and the views expressed here are my own and do not necessarily reflect the policies or positions of Johns Hopkins University. Research shows that FFLs breaking the law are major channels of trafficked and illegally purchased firearms, which are among the most common methods of diverting firearms for use in crime. Some of these cases involve thousands of trafficked firearms by the same FFL. Maryland currently holds gun dealers criminally liable for selling a handgun to someone they know or should know is buying a gun on behalf of someone else, often a prohibited purchaser, known as a straw purchaser. We can all agree that this is a common sense measure. However, we do not position licensed dealers and their employees well to identify these straw purchasers. Neither federal law nor Maryland law currently requires firearm dealer employees to undergo training to spot illegal sales. Maryland should require gun dealer employees to be trained in how to spot and stop illegal gun sales. As mentioned, several states have enacted laws requiring gun dealers and their employees to undergo training to identify and prevent illegal sales like straw purchases. States with their own strong regulations and oversight of FFLs have lower rates of firearms being diverted for criminal use than states lacking those regulations. The training requirements in SB 692 will equip licensed dealers and their employees with the skills to more effectively prevent access to lethal means by those who are prohibited from owning them. This past Saturday, I attended a memorial service for a friend who was shot and killed in Lithicum last month. His death serves as a reminder that life is precious and should be protected. I simply request that we explore all options with the potential to save the lives of those we hold dear. I urge for a favorable report of SB 692. Thank you for your time.
Thank you. We have more proponents online, but let's take a break here and just see if there's any questions. Senator West. Yep.
Mr. Vice Chair, just for the record, I wanted to clean something up for it.
Sure.
The piece that was amended, it's in the interlineated copy, the piece that mimics what we have in the safe storage statute, I want to read that into the record so that I clean that up. So the relevant part would read, compliance with or violation of this section may not be considered evidence of negligence or recklessness, limit liability of a party or an insurer, or diminish recovery for damages in a civil suit for damages. And then the next part is a party, witness, or lawyer may not refer to a person's compliance with or violation of this section during a trial of civil action that involves property damage, personal injury, or death. That's the piece that mimics what we have in the safe storage statute. Just want to make sure I cleaned that up for the record.
Thank you, Mr. Chairman. Senator West.
Thank you, Mr. Chair. I do have a couple of questions. In general, I think the bill is meritorious, but I need to ask some questions about certain components of it. First of all, this annual training. Now, I'm a lawyer, and I've thought for years that Maryland ought to require continuing legal education for lawyers because the law evolves sometimes radically. And in order to stay abreast, lawyers need to have this annual training, in my view, to be a competent professional. But I'm not sure that selling guns evolves that much from year to year. So is your intent in the bill that each licensed dealer must annually undergo the entire training from scratch that he got the year before, the year before that, and the year before that?
So, yeah, so the amendments say that it's going to be conducted semi-annually, so that's one thing that bumps out. Second is that it's, the structure of the course and the question answers 25 questions, but yes, the short answer is yes. On a semi-annual basis, someone would have to refresh their training. As we all know, training is perishable.
And take the whole original training all over again?
The test.
Twice a year?
Once every 2 years.
Oh. I thought you said semi-annually. You mean
biannually? Sorry.
Biannually.
Yes, yeah.
Okay, that's a little better. What about employees? If you have in these large establishments, you got to have an employee just stock shelves, never interacts with the public at all, and maybe it's part-time. Are we talking about all employees, or are you going to qualify the definition of the word?
No, as I mentioned during the testimony, and I know it's going quick, but it's one of the amendments, and you don't have the interlineated copy before you, so that's why you don't know. But it's the amendments will say that only the employees that are engaged in the transaction of sale, not someone that's stocking shelves or the like. So that's what I'm offering.
Okay. Next question: the training course. There's no indication of how long the training course should be. Is it 2 hours, 5 hours, 30 hours, 6 months? Is there any limitation to what can be prescribed by law that these people have to subject themselves to biannually?
These requirements mimic what we found for cannabis, for cannabis dispensaries, and or for if you're engaged in the sale of tobacco or alcohol. Admittedly, tobacco and alcohol is every 4 years. I think cannabis is every 2 years. And so what they've done is there are vendors that create these courses and use kind of off the shelf. And here, the state police, the Secretary of State Police, under their purview, would develop or would set forth the standards of that training program, which consists of 25 questions. And so that's what you'd have to accomplish and get that certificate every 2 years under this bill, under the amended bill.
Okay. Next, we're talking about the nature of the training. The first element is state and federal laws regulating the transfer of firearms and ammunition. Ammunition can be sold by stores which are not licensed by the federal government, FFLs.
We're not talking about lead bullets here, Senator Cole, just so you know.
So why is ammunition? Wouldn't it be appropriate just to limit out the firearms rather than ammunition as well?
Certainly open to adjustments to the content of the course. This is a component that was found in the other states that have adopted similar measures. Obviously, ammunition is a core component of firearms activity, so we thought it necessary, but certainly willing to discuss things that you think are more germane to the purpose of the bill.
Okay, a couple more questions if I could. The third element is teaching customers firearm safety. I've never bought a firearm in my life, but I would be surprised if I went into a store to buy a firearm if the person behind the counter were to insist on trying to teach me firearm safety. Does that happen? And if it doesn't happen, why are we requiring that employees at these stores learn how to teach firearm safety?
Again, willing to work on language to refine the content, but the goal here and my vision would have been that you'd get someone that would advise you on safe storage and where you could seek training and guidance on the safe operation of the firearm. Much like if you were to purchase, some sort of a complicated tool from a hardware store, you'd get some cursory advisement of, hey, look at this thing, operate this carefully, here's how you do this. Much like if you bought a car, that type of thing, you purchased an automobile.
Then there's another provision, recognizing and reporting to law enforcement signs of D, an individual who intends to use a firearm for an unlawful purpose or self-harm. It strikes me if I developed an intuitive sense that someone might be intending to buy the firearm in order to use it illegally or to use it to inflict injury on themselves and reported it to the police, and I were wrong about that, and the police started an investigation, isn't it possible that I could be sued for defamation?
Defamation's a very high standard, so I don't think that's within the orbit of possibility, but that's why, out of our abundance of caution, put in the same language that we have in the safe storage statute to protect someone from that type of liability. Should they, should their activity be deemed to not fulfill or fall short of the training that they were given. I think it's important to have a cursory understanding of the state and federal laws and understanding what straw purchases are and the dangers of trafficking to help diagnose and report that suspicious activity.
But this doesn't refer to laws. It says reporting to law enforcement signs of an individual who intends to use a firearm. So, what, nervousness, twitching of the eye, that kind of thing? Would that
any
kind of conduct result in a requirement that the person who's selling the firearm make a report to law enforcement of this particular individual?
Any activity that squints toward a violation of that state or federal law, I think, would be advisable to report to law enforcement.
And then my last question, actually two more questions. The online, is it an online exam?
It's an online proctored exam.
Online exam. How are we going to make sure that the person who takes the exam is the actual person who is going to get the certificate as opposed to someone he asked to take the exam for him?
Much like, I mean, we can explain this, but much like what's done with the Cannabis Commission and with alcohol, you have a registration, you have an email, you have a registration, and so
that's possible.
It certainly could be circumvented if you really wanted to commit that type of fraud, but I can also defer to you if you want to answer more. But I mean, that's the way it works with these other mechanisms that have been working successfully in Maryland.
Okay, and then the last question is, I looked at the fiscal note. There's a significant fiscal note. It's over $1 million in the first year, and it's over $250,000 from then on. Do we have permission from budget and tax to spend that kind of money?
That fiscal note was developed under the prior bill with absent the amendments. We've worked with Maryland State Police. They are no longer required to develop and administer and proctor this exam. It's going to be an off-the-shelf product administered through the internet. So those fiscal concerns, I think, are largely addressed. I will not testify that their concerns are all assuaged by the amendments, but we'll continue to work with them.
Okay. Thank you for your answers.
Thank you. Any further questions for the sponsor? Senator McKay.
Thank you, Mr. Chair. Thank you.
Yeah, you've got experience in that, too.
Thank you, sir. My question has to do with the certificate that's going to be issued by the Secretary. Is there any time frame that the Secretary has to issue that certificate?
The certificate is issued upon completion of the exam.
So it's an automatic?
So you just print it out and you keep it with the employee file.
Okay, okay.
Or you can have a digital copy that you save with a digital file with the employees.
Okay. Yeah. If there's any kind of delay or anything like that, can an employee still be working during that time frame? I mean, if it's going to be downloaded but if there's some form of a quirk or whatever, is there any kind of violation for the employee to continue working while they're working the bugs out?
No, I mean, it's instantaneous as soon as you complete the course, and then I think we've put in a 20-day delay for new employees, but it's instantaneous once you complete the course, and you could just literally just, you'll have it on your desktop or you'll have it accessible there. But yeah, I mean, I think that's the answer to the question.
Okay. Long ago, we had a health insurance website that didn't work out too well.
So I remember.
So that's kind of the genesis of my question. Thank you, sir.
No, I hear you.
Thank you, Senator.
That had broad implications for future.
All right, here's who's next. We're going to mix some in-person and virtual testimony. I have Nyla Jimenez in person. Come on up, please. And then I think the rest is virtual. I'm sorry?
Layla Gretton.
Oh, there you are. Yep, Layla, please come on up. And then we'll also take Aaron and Mary online. And Steve as well, Mr. Lindley.
Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and esteemed members of the Senate Judicial Proceedings Committee. My name is Layla Gretton. I'm a high school student at Archbishop Spalding and the founder of Team Enough Baltimore, a youth-led initiative under the Brady campaign. I'm here today to voice my support for Senate Bill 692. And as the president of Team Enough Baltimore, I lead nearly 50 students across Maryland and multiple school chapters with a shared passion and commitment to gun violence prevention. Firearm dealers are on the front line. They are the only barrier in place that can prevent someone who should not have access to a gun from accessing one. Even the National Shooting Sports Foundation agrees. They highlighted a story about a firearm retailer who denied the sale of an AR-15 to someone who was clearly exhibiting signs of a potential criminal purchase in Missouri. And by noticing the odd behavior and questions the individual was asking, this retailer prevented the sale of a firearm to someone with a history of violence against Americans. Educated employees will be able to respond to red flags indicating a possible straw purchase. For example, someone unwilling to undergo a background check, unfamiliar with a firearm they are purchasing, or someone who's communicating with someone on the phone during the purchase. According to the ATF, traffic guns are used in twice as many shootings as guns that are not trafficked, meaning identifying straw purchasers is a prime way to actually prevent violence and save lives. Training will lower dealer liability by ensuring they have a comprehensive understanding of federal and state law, as well as ATF updated policies. The importance of a standardized training program is accepted not just by stakeholders and advocates, but by gun dealers, the NSSF, the Firearm Industry Trade Association, and ORCID, a compliance firm known for consulting the NSSF, all of which have advocated for and educated dealerships about training. The truth is, Maryland is in need of common sense gun laws, and I cannot think of a more perfect fit than this bill. Let us take a supply-side approach and prevent tragedy before it happens. Firearms should only be accessible to legal and responsible gun owners, not those with the capability or intent to harm. I strongly urge a favorable report on Senate Bill 692. Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and esteemed members of the Senate Judicial Proceedings Committee. My name is Nyla Jimenez. I'm a member of Team Enough Baltimore, and I'm here today to share my story and support for Senate Bill 692. When I was 15 years old, my father was an alcoholic. He was both verbally and physically violent and expressed suicidal ideation. As his disorder progressed, my father would wake up in the middle of the day screaming at my mother and me, asking why we were breaking into his house, often not recognizing us. He was convinced someone was trying to kill him, so he would wake up and randomly leave the house to hide. There was never anyone who wanted to hurt him, and these were just outbursts of results of childhood PTSD. One morning when we were driving and while he was drunk, he pulled over and showed me the recently purchased firearm. I want to make one thing clear. From when his disorder seriously begun until he sought rehabilitation, I did not see my father sober once, not for an hour, not even for a minute. He was always under the influence. This means I can guarantee without a doubt that he was under the influence of alcohol when he purchased this firearm. The presence of a firearm only escalated this and put me in fear for my mother's and I's life. My father was erratic, delusional, and furthest from responsible. I feared that in one of his episodes he would go as far to use the firearm to commit suicide. That gun should have never made it into our home, period. Educated and trained employees can notice individuals exhibiting warning signs, including those of my father in crisis and under the influence. This bill would keep children like me safe. Therefore, I strongly urge a favorable support for Senate Bill 692. Thank you.
Questions from the committee? I just personally want to say, Nyla and Layla, thank you both very much for coming down to take time out of your schedule to testify. And for Nyla, thank you for sharing your personal story. It's always really important to have people come down and share their stories to help shape policy. And Sometimes it's more difficult than other times, but I wanted to say just thank you for doing it, and I appreciate your advocacy.
Thank you.
It's also good to see young people plugged in. It's good. It's locked in. You're going to take our jobs soon. So, all right. With that, that'll conclude the testimony for the proponents of the bill. I think we'll now switch over to those signed up in opposition. Hold on. Actually, hold on. Wait, virtual. Sorry, we've got the 3 virtuals. We're going to start with you, Aaron. Welcome back. You're up.
Good afternoon, Mr. Chair, members of the committee. Again, my name is Erin Earp, representing the Giffords Law Center. I'm here to testify in support of SB 692, which will ensure that firearm dealers and their employees are properly trained to prevent firearms from ending up in the hands of those who may cause harm. Under Maryland's industry accountability law, dealers are required to implement reasonable controls to prevent sales to straw purchasers, firearm traffickers, prohibited people, and others. They're also required to take steps to prevent loss and theft of firearms and ensure that they comply with all state and federal laws. This bill creates a pathway for dealers to ensure they comply with these requirements by taking the training approved by the state police, which covers these same topics, and by also having their employees take the same training. As previously stated, this is an online training that is accessible, and an individual may also retake the exam if they do not receive the 70% until they do so. These legal requirements are already in effect, and so it's critical to ensure that every dealer and employee understands what their legal obligations are when it comes to selling firearms. This will not only prevent harm to the community, but prevent repercussions to dealers for failing to comply with these standards. And so I urge a favorable report. Thank you.
Hey, Mary, you're up next. Welcome. Good to see you.
Good to see you too. Thank you. Chair Smith and members of the committee, my name is Mary Kana, and on behalf of Everytown for Gun Safety, I'm here to testify in support of SB 692, which would standardize training for firearms dealers and their employees. Gun dealers play an important role of gatekeepers to firearm purchasers, and their conduct can contribute or prevent guns being diverted to the illegal market or made available to people who are likely to harm themselves or others. Despite these risks and the fact that gun dealers play a critical role in preventing gun violence, federal law does not sufficiently regulate them. Maryland must step in to do so, and an important aspect of dealer regulation is requiring training on recognizing the signs of illegal activity and knowing and understanding state and local laws. Standardized and periodic training is an effective tool for dealers and their employees to ensure they are engaging in safe and legal business practices. It gives employees and dealers the knowledge to prevent straw purchases, gun trafficking, and theft of firearms and ammunition. Those permitted and allowed to sell firearms should be required to complete some form of training before engaging in this industry, similar to many other industries in the state. This bill requires dealers and their employees to semi-annually take a training course and successfully pass an examination. This balances the need for dealer training with the demands of running a business, ensuring compliance with the law while not hindering business activity. Training gun dealers and their employees can make a difference. The ATF has said that gun dealers can significantly reduce the risk of straw purchases at their stores by educating employees on recognizing and responding red flags indicating a possible straw purchase. By requiring training for all gun dealer employees, Maryland can prevent tragedy before it occurs and proactively fight crime. On behalf of Everytown for Gun Safety, I request a favorable report. Thank you.
Excellent. Thank you very much. All right, Steve, you're up.
Thank you. Good afternoon, Chair, Vice Chair, committee members. Thank you for the opportunity to testify today. Again, my name is Steve Lindley. I'm a law enforcement professional with over 28 years of experience, including more than 8 years as the Chief of the California Department of Justice Bureau of Firearms, where I oversaw statewide firearm regulatory programs and enforcement. I currently serve as a senior advisor to the Brady campaign to prevent gun violence, and I've testified across the country on firearm policy. I'm also a high school teacher. For over 10 years of my 28-year law enforcement career, I have had the opportunity and responsibility of ensuring that firearm laws are not only well designed, but also effectively implemented. One consistent lesson I have learned, whether at the local, state, or federal level, is that strong and effective laws require trained and knowledgeable people to enforce them. This bill addresses a critical gap by requiring licensed firearm dealers and their employees to complete a training and pass a written examination on core responsibilities, including the firearm laws, safe handling, theft prevention, and identifying illegal activities such as straw purchases and firearm trafficking. As a former law enforcement officer and current educator, this is a simple common sense. I have firsthand knowledge and actions observing what dealers can do and cannot do in order to divert firearms into the legal market. When dealers are properly trained, they can identify suspicious transactions, prevent illegal sales, and alert law enforcement before crimes occur. This legislation reflects best practices implemented in other states where training, compliance, and accountability are essential to effective regulatory of the firearm industry. For Maryland, implementing Senate Bill 692 is cheap, effective, and common sense, especially when compared to the cost of firearm violence. An ounce of prevention is worth a pound of cure. Thank you for the opportunity to speak today, and I ask for your favorable support.
Excellent. Thank you very much. Questions from the committee for our panelists who are joining us virtually? All right. Seeing none, thank you all very much. That will conclude the testimony for the proponents of the bill, and now we'll switch over to the opposition panel. Hear first from Mr. Jocelyn, who is here in person, and then Mr. Pennick, if you're still in the Zoom room, you'll go next.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for 2A Maryland in opposition to Senate Bill 692. The bill provides that the Secretary shall provide at least one course. It also says that he can add or she can add subject matter at will whenever it's deemed appropriate. You could have an endless number of topics you would have to teach. Most problematic is the training part. In order to teach Maryland's handgun qualification license course, you have to become a state police certified instructor. The same for the carry permit course. There are no requirements in this bill for the credentials that the employee must have in order to train a customer on the listed topics of firearm safety, handling, and so forth. Most dealers do not have the physical space to sequester a customer to do proper teaching. Fewer still have a range. So between the combination of an unlimited number of topics, firearms training that the employee may have no formal training, there's no requirement they be an NRA instructor or a CCW instructor, simply an employee who's taken this online course. I think what we have here is a recipe for disaster, because people will be getting the training course and say, oh, I've been trained, I'm good, when in fact, maybe they didn't get enough. This leads to a false sense of security. Dealers are dealers. Car dealer doesn't teach you to drive. Pot dealers don't teach you how to smoke. And the firearms dealer shouldn't be in the instruction business. They should be in the sales and maintenance business. We ask for an unfavorable report on this bill.
Excellent. Thank you very much. All right, Mr. Pennick, you're up. Welcome back. Sorry, we're on mute again. 1 second. There you go.
Thank you. Mark Pennick, President of Maryland Show Issue. I'm in opposition to this bill. And first, I'd like to applaud the chair for the amendments that he's offered today. And I think those are excellent amendments, but we would endorse particularly the incorporation of the safeguards from 4-104 of the Safe Storage Act not being the basis for any civil or criminal actions against the dealer. But apart from that, I will say this bill is duplicitous in great measure of the efforts of federal authorities, including the ATF, which already provides to dealers on an annual basis a complete documentation of all federal and state firearms law that dealers are already required by federal law to comply. So by giving you citations in the written testimony, that's already the law. So you have as well existing state law, which impose a comprehensive series of regulations upon firearms dealers who are already required to comply with this. So the only thing that this bill really adds is a test on things that are already required by state and federal law. So the test is simply a means of administering something that they're already supposed to know. But I will tell you that the test isn't going to accomplish very much. And I will give an example, and just to respond to the chair's reference to the Montgomery County litigation, the Attorney General sued against those 3 dealers in Montgomery County and joined by DC. The Attorney General lost. The district court dismissed the complaint. And the reason the circuit court dismissed the complaint was because the dealers in that case sold firearms completely legally to a designated collector who had passed multiple background checks, including the HQL and a designated collector test. They did everything by the book, and yet the Attorney General would still like to hold them liable. So I don't think that's a good example that would support this bill. So I'm happy to entertain questions on that. Thank you.
Excellent. Thank you both very much. Questions from the committee for this panel? Senator West.
Yeah, Mr. Chair. So, Mr. Pennick, we heard testimony that 40% of the guns that are used illegally in Maryland are sold by Maryland dealers. When the dealers sell the guns, they record, don't they, the serial numbers on the guns? So we know who,
Yes.
we know who they were sold to, right?
Of course. In fact, the state has a very elaborate system already in place that is designed to prevent straw purchasers. They have the HQL system. They have the 77R. You cannot buy a regulated firearm without it being approved by the state police. In the
So
Montgomery
I may
County
be
example,
naive, but I don't understand how if the dealer sells a gun and records the name of the purchaser and the serial number, and then the gun is used for crime and recovered, and there's a serial number on the gun, that why can't the law enforcement go back to the purchaser of the gun and find out and trace the gun from the purchaser to the person who committed the crime and find out what's going on?
that's exactly.
Do they try to do that?
Yes, they do. And they do indeed do gun traces. And those are governed by federal law, and ATF does that, and local law enforcement does it. Can request a trace of ATF databases at any time, and they can go back to the original purchaser and find out if he was in fact a straw purchaser and bring charges. Unfortunately, there has been a dearth of law enforcement. So the problem with this bill is it seeks to transfer some of these law enforcement duties from law enforcement to the dealers, who are now expected to report things to law enforcement, which they are already not enforcing. So yes, you can do a trace. Yes, you can find out who the original purchaser was. And yes, you can trace it after that to whom he sold it. That's the whole idea of having a serial number. And yet we have a dearth of law enforcement on that. If they actually would enforce existing law, a lot of straw purchasers would go away because they would be incarcerated. It is a federal felony to purchase a firearm in this manner.
So your answer to my question is to why 40% of the guns that are used for crime in Maryland are sold in Maryland gun shops is that the police don't have enough, manpower to investigate these situations and prosecute the criminals?
We know for a fact that straw purchase regulations are seldom enforced in court. They just are.
Okay, thank you.
I think just for the record, the point of noting that 48% of those firearms that are sold that are in that are involved in crimes that are sold from Maryland FFLs is that the training is a preventative, proactive solution. And so you'll never be able to prove a negative, but it's to be proactive. It's not a back-end solution to incarcerate people that have been convicted or charged with straw purchasing. It's a proactive solution to help people identify potential problems at the onset, as opposed to the back-end piece, which is where the law enforcement action comes in. But
so if I may, Mr. Chair, I'll respond to that briefly. So no dealer.
Usually we don't do it, but since I like you, and we have a good relationship, and you've helped this committee out before in the past, you go ahead. But
thank you, Mr. Chair. I do appreciate that. I will say that no dealer that I know of, and I represent more than a few, wants to engage in straw purchasing. They all know it's illegal. They all know that they're seeking to prevent it wherever they can, and every dealer that I know of seeks to avoid that. It's not necessarily something that's easy to control. No one comes into a dealership and says, I'm going to buy it for X. And when they do, that's almost uniformly said, well, I'm not selling it to you. So straw purchaser can surreptitiously lie on a 4473, federal felony, lie on the 77R, 2 state misdemeanors, perjury and misrepresentation, and get away with it. So to expect a dealer to serve as some sort of screen of that beyond what these existing requirements, it simply isn't reasonable because there's no way for the dealer to know, which is why the Maryland Attorney General's suit against the dealers failed.
Yeah, no, I don't want to get back and forth, but yes, the thrust of the bill is to ensure that everyone has a base level understanding, not that we're trying to deputize every employee that's at the point of sale in the FFL to actively screen and, engage in these activities, but just to have a base level understanding so that if something seems wrong, or they can report that and potentially prevent a deadly sale. But we'll rest there. I really appreciate you all. Thank you all very much. This is the last hearing of the day, last bill of the day, so I don't want to keep the committee longer. But appreciate you all. Thank you all for sticking in there with us, and looking forward to working with you all.
Mr. Chair, since we testified together last year, could I call in a favor?
You would have asked the committee members here. That's a good card to pull, man. Yeah, but we did testify together, and I enjoyed it.
You had the picture taken, Senator. I didn't.
We will get 30 seconds.
30 seconds.
30 seconds, and then the committee's going to kill me.
Something we have not considered is that there is a very specific insurance policy for instructors that is not part of a dealer's general liability. And when you start engaging in instruction to a customer, you now expose yourself to the liability that an instructor would have, and each one of the people teaching would have to have an insurance policy that covered them as an instructor.
I've got a
They would have to
rejoinder, which
provide
we'll
the
take
company with their
offline.
credentials.
Appreciate that. All right.
Thank you, Senator. Have a
Thank
good
you
day.
very much. All right, with that, that'll conclude the hearing and the hearings for the day. We'll see you all tomorrow morning on the floor.